12. Item 13 to 27.
Item 20. 25.
Item 20.
Item 20. Calculation number is going to be filed variable.
We'll see. Who has to file calculation memo? Yes.
I informed my client yesterday. I prepared.
We'll see. Please wait for orders. It is in the caption. Please wait. We'll see.
Item number 3.
Yes, madam.
Next Thursday.
Why? What's the noise? Everything.
Next Thursday.
Every problem then.
The second respondent union.
Your problem. What is the issue?
Regularization of the contract.
It's 1 week. It request to the law. 1 week. Same caption. Yes.
Same cap.
25.
Yes.
And again on 16.
Why? Why? Yes. 25. Let's request to the petitioner. You are appearing for Monday. Monday. Yes.
Item 28 to 38.
Item 35. File counter in this matter.
Please wait. Please wait. Till we just yes.
Item 39 to 52.
Yes. Monday. Monday means Tuesday. It will come on Tuesday.
Item 53 to 64. Item 65 to 74.
Let's call the list. Yes.
68.
68. Monday.
Take a list. Only
No mention. 105. Yes, item 105. When the matter is taken up for hearing, the council appealing for the petitioner submits that. What is your name, madam? T. Rajalakshmi, representing the Yampan. Council appealing for the petitioner submits that. Due to effect of the time, the call in the petition does not survive for adjudication. May therefore petition is dismissed as suspicious. Yes.
HIGHCOURT directed to list matter on Wednesday was shortlisted and came up for extension of his pending proceedings.
Which one?
CRP.
Tuesday.
Step only to
It is to be listed. 2:30. So. 2:30. Yes, call the rest.
162, 163, 164. I am for the respondent. The matter will become infected.
You are for the respondent.
Respondent.
Who is
The name of the petitioner is not printed. According to me,
160.
162, 163, 164.
You are
Respondent.
KV Satyachandra Rao.
Ramchandra.
What is the issue?
Grantee of domestic inquiry that was initiated by the tribunal against that they filed a petition.
Yes.
These workmen also reinstated and work in the petition organization.
Yes.
Therefore, the matter will become an infectious.
There is no stay.
There is no stay. They are also working in the establishment.
Maybe. Because what is the order of the tribunal?
The inquiry conducted by the management is initiated.
Yes. What is the order? With the continuity of service, only reinstatement is ordered, or continuity of service, back ways, attained benefits?
Only reinstatement continuity.
Continuity of service.
Continuity service. This matter is only they are challenging the order passed by the tribunal on the ground of inquiry is valid.
Yes. Who is appealing for petitioner?
The name of the petitioner is not printed.
Seems somebody. Which organization this one?
Jubilees International Center, that day, Lordship passed an order, there is a settlement between the.
Yes, yes, Hariharan, Mr. Hariharan.
Mr. Hariharan.
Yeah, 162. These are mostly, madam. This is Lakshman Gandhi appearing. Shouldn't be, you can notice that also for our sake. Sure. We'll see, please wait.
One or three also to be posted next week.
One or three, yes. Monday, Thursday already. Monday, yes. Monday, that's Tuesday, yes. 87, specially identified, no agenda. No mention, yes. 87, this end, yes.
My lord, series number 152, my lord. 152 series number, my lord.
Have you seen the list or not? No adjournment should be granted in specially identified cases.
My lord, I need to get instructions, my lord. It may be posted on Tuesday, my lord.
What do you want, madam? $146. What is the issue? We'll see, yes.
My lord, please be considerate, my lord. Series number 152. I'll get instructions from the client and
Sir,
get back to you, my lord.
but you follow the code. We are specifically mentioned in the list, or top of the list. Have you seen or not?
Yes, my lord. Sorry. Much of it.
Next week, verify and post next week.
It is for regularization of services by the proposal of the government, and it was released in 2015, and the petitioner is going to retire next year. So it can be taken up on Tuesday or anything.
Next week. Which year matter?
2017.
Counter is fine. Counter is fine.
Yes.
Yes.
Petition 2028 of 2014, my lordship. Petitioner is a senior citizen and suffering with old age.
What do you want now? What is the issue?
Property issue.
Property is this which only deals with the service matter.
So, this matter.
Verify and post next week. Yes.
Show me your first matter parties to those covered by division by book.
That's next week.
On me mention. Item 1, to state was data per label.
Oh, no. Other. Madam. This should not complete. In this matter, on 16/4/2014, this court has passed order allowing counsel for the petitioner is permitted to take out personal notice to unserved respondent number 1. Respondent number 1 is the workman. Yes. by register post with acknowledgement due within 6 weeks from today and file proof of service, failing which the requisition shall stand dismissed as against unserved response without further reference to the court. Without looking in.
Watchmen pass orders on merit.
Even the requisition is allowed, it's not binding on the first respondent. Shall we pass orders? Because
Yes, my lord.
because
Then
on
once it is
T11 2013, we have issued fresh notice to the respondent.
again,
That is the reason it is there.
when I also verify with my budget, whether any notice was served on the register or not.
Thing is on card. No, Valdi. Well, proof of service file is there. Verify and inform to the court Tuesday. Whether we will pass orders, what is
Yes.
then implemented?
Participant, item 2, Pasan Srinivas Reddy, Lord 71.
Pass.
My lordship, I am appearing for respondent numbers 2 to 5 in this matter.
Also,
The council passed away, my lordship. That is what I want to inform. The council for petitioner passed away. Notice has to go to the petitioner directly, my lordship. Pasan Srinivas Reddy, the learned counsel for the petitioner, my lordship, passed away. It was notified in the bar earlier, long ago, in fact. It was about a year. Personal matter has come up now. So, my lordship, actually, notice has to go to the petitioner personally now.
Yes. What is the issue, sir?
My lordship, this is a matter concerned with the Central Labour Commissioner, wherein on Minimum Wages Act, he has passed an order which was challenged by the petitioner, who is a contractor. The BSNL is in fact, the employer which has taken on this particular contract labor. So with that, we were made parties respondent number 2 to 5. Central government is respondent number 1. The basic issue is now the council is no more.
Yes. Stop. You got to know the report. The council on card.
Item 4, please read the draft, Ladan Srinivas.
My lord, adjourn the matter, my lord, for notice is on.
Notice 4 weeks.
Any personal notice, my lordship?
Person who has to take personal notice.
Only respond. I think let the notice go from the court. I think that is appropriate, my lordship.
Yes.
I am obliged, my lordship. Highly obliged. Grateful to lordship.
Yes, madam.
We have certain conditions to the petitioner. They impose certain conditions. Here this matter finds a condition. Petitioner was a bus driver, was appointed in the month of June 1980, and was working with the third restaurant.
What is the issue?
Issue is they're not paying the monetary benefits for lodgers.
Where is Gaddam Srinivas? 2005 order you are challenging 2011. Also, let me come.
Item 5, DP for services free.
Yes.
Seeing the ID order similar is the 63 of 2017, dated 31/1/2009. After the passing of the ID order similar, the respondent not approach the department. They have not communicated, they are not working in it. According to the instructions, the respondents not working in this department.
Where is the order? Since it is a batch matter, what happened to connected
Only
matters?
10 members is working in this department.
What happened to connected matters?
Only 106 in this respondents also not continue the department. Not
No, what happened to the repetition? Earlier, some of the repetitions were decided by the court.
3 or 4 cases is
What happened to that?
that is petitions are working is disposed of. Based on this
Against which ID? What is the ID number?
taken the ID is not last.
This repetition is filed against which ID? The present repetition is filed against which ID?
63 lawsuits. The ID number 63 order dated 31/1/2009.
Please read the relevant portion where it was discussed regarding IN 63. Photo of the delay copy. Red copy. Red copy leda. Only one. Total 29 IDs.
7 members is
You construct your but because this is ID 63. I'll read one second.
instructions not continue the department after the passing of the ID orders did not approach the department. It is working some other places.
No, I will inform to them. Where are those circulars?
Only not 7 members placing on this different IDs.
No, have you communicated any appointment order or letter, addressed a letter in person to the interim this ID award? There is no stay in your favor in this case. With the respond, you want to know.
Notices
Once R2, respond number 2. So, Pakalate email. Evaru? Sudhakar. Yes. You stated in your counter stating that the petitioner never worked under the respondents. In fact, there was a ban on engagement of laborers in department as per GO 143. Hence, question of engaging laborers after 16/3/1984 does not arise. Submit that the petition is a stranger to the respondent. The petition is filed with an ill motive. We'll see how the tribunal discuss this. If in that 1 week time, construct your bundle and then. Yes, 106 also in the post next week, next Thursday. The request to the government will post next Thursday and delete from the cabinet for answers.
Item 6, SM Sugar, Case Canvas Study.
2 weeks last.
My please, Lordship.
2011 matter.
Yes.
On Thursday. Both 106 are. Madam, 106 please. Yes,
My please, Lordship. The page number 17 is the metal paper. Facts of the case is that he worked in the TSRTC and retired from service in the year 2011. So while retiring, some of his criminal benefits were withheld by the corporation, stating
12
that the
12/9 none appears, 29 none appears, 27/9 none appears, 4/10.
sorry for the inconvenience.
Sorry,
Sorry for
none.
the inconvenience.
What is this?
Sorry for the inconvenience. That's the reason why I'm- Page number 17 is the impugned order. Lordship, kindly.
Yes,
This says that house building advance was advanced to him of 1 lakh,
read.
and at the time of retirement, they said that the interest rate.
Banji, please read the 17
Madam.
page. Please read that.
Yes, return of house documents of the so and so of Jahirabad Depot with reference to the subject cited, your HBA requirement and audited and certified by AO MR as follows. Interest from 12/1/90 to August 2006. Penal interest on EMIs not recovered, that is 10,113. Penal interest, that is 58,000. Total it was as 1,41,348. This amount was withheld. My submission before Lordship is by 1996 the loan was entire loan was recovered. They have not cleared the closed the loan account.
Where is the material?
Yes. Page number 15, Lordship, kindly.
Yes.
Adverting to the subject cited that house building advance was sanctioned to me in the year 96, was given in 3 while working at Siddipet Depot and Sangar Depot. The advance taken has completely paid completely by August 1996, but the interest have to be calculated and recovered on the advance is due so far. I informed the same to the concerned in ED Hyderabad Zone Office. They stated that the process of calculation of interest and advance has to be done in the accounts office concerned itself. Therefore, you are requested to look into the matter. He filed representation as on 10/8/2007 itself. But the same was not rectified and the account was not closed. And now this amount was withheld from his terminal benefit. Interim order is there, Lordship, may kindly see. There is an interim order.
Yes, terminal benefits are paid or not so far?
Not paid, my lord. That is the reason we have to pull out. Instead of the interim orders also there, that was withheld, and since 10 years, those amounts are with them only. In fact, the loan was recovered and it was paid, and account has to be closed by themselves. Without closing that account, charging the interest of, with the petitioner, that is the workman, is an arbitrary action on the part of the respondent corporation. That's the reason why interim order was passed. Interim order was also, no benefits were paid.
You have not filed any contempt.
And this is not
Yes.
filed.
Coming into the capital, a number of times was adjourned because absence of non-appearance of counsel. You should have filed counter at least all these days. Well, just now read. Since it's coming from 19/4/2023.
Yes,
19
yes, yes.
28/8. 4/9. 12/9, 29, 27/9, 4/10. Every time is not appearing. Suman has become very busy. You are also not.
No. Sometimes I have paid. Last 3 occasions, my lord, the lordship knows due to bifurcation of the court, we are suffering a lot. That is all the reason. He is a
Fine.
senior citizen and now 17 years old, 70 years old, and he is suffering a lot. His terminal benefits are withheld, though the amount was recovered from his salary.
On 3/4, you have filed a letter to the registry, address a letter to the registry to list the case.
Yes.
Then you are not appearing the matters where it is listed.
Sorry for the inconvenience, Lordship, kindly consider. Your Lordship knows it very well. How much we are entrusting to the juniors, they will not appear, and some problems are there.
Either with the proof of payment or with the counter agreement.
Post on Wednesday. The same caption. Will be there.
Much of it.
Wednesday. I request the respondent to get instructions for compliance of the orders. Post on Tuesday, Wednesday.
Much of it. Deeply obliged. Sorry for my inconvenience.
Yes, it's no issue.
Item 7, D. Krishna Rao, B. Uma Devi. Case
My
statement.
lord. My
Yes.
lord. My lord, the petitioner was an employee of the Gramin Vikasa Bank.
Pass over. Yes.
Much obliged.
Item 8, J. Parthasarathi, B. Uma Devi.
My lord, at item 8 and item 9, the respondent, they filed against the corporation bank. The corporation bank is no more in existence. It was merged into Union Bank of India.
2014 matter. You are appearing for Union Bank.
No, corporation bank.
Request the patient to take steps. Post of test. Post on 21. Both the banks. Both are same.
Much obliged.
On the caption for this.
Item 10, M. Vishwanathan, B. Sriharsha Reddy.
Pass over.
Item 11, Gopal Rao Amchandra B. Tom Srinivas, J. Paper Lane.
Yes.
Will also record the memo and this was
Yes. Yes.
Item 12, Rajgopal and Science, GPFS School Education, GPFS Service Implement. What is that?
Action of fraud extraordinary is some pay for the period of paid expansion. But this is not to calculation. Especially couple of days touch.
Yes,
Thanks.
little louder, we are unable to hear you.
Government has submitted
When the matter is taken up for hearing, I seen from the proceeding sheet on 27/4/2023, I has learned government to have requested time for getting instruction with regard to the letter dated 9/10/2022, which is mentioned in para number 12 of the counter of filed by the DEO Hanmakonda. Matter was posted to 8/6/2023. On 8/6/2023, also at his request, matter was posted to today. Today also learned the government play for service 76 further time. At his request post on 13/7/2023, finally, no further adjournments will be granted.
Recent memo dated 9/10/2023. Recent memo.
What is that memo?
Regarding the sanction of the blood.
What is the issue, sir?
what has happened is the petition was working as a petition.
Yes,
Lordship in the Kottagudem Khammam Lordship.
yes,
He was illegally transferred. Then he filed a writ petition Lordship that the transfer orders were set aside by the Honorable High Court. In the meantime, Lordship, unofficial respondent was appointed.
mostly in the same place.
In the same place, not
Yes.
unofficial respondent. Some other teacher was placed in the same place.
Yes,
So he filed another writ petition to retain it. This honorable court granted stay. So this petitioner could not join the place where he was. So in the meantime, he was retired. We are asking for the salary.
oh, who is appealing for the institution? Yeah.
What has happened, Lordship, the counter has been filed by the government.
Yes.
12 of the counter, Lordship, for a minute.
Yes,
For a 12 of the counter.
yes, sir, great.
Whereas the district education officer Mehboob was addressed a letter to the respondent to director of student affairs to pass necessary orders in the matters of extraordinary leave period from 28/4/2022 up to the date of requirement of the petitioner for consideration of payment of salaries.
Yes,
Now, Lordship, they issued the present memo, which was furnished to you on 29/9/10/2023. He was issued for payment of consideration for payment of salary.
yes,
Now, Lordship, this memo is issued by 9/10/2023.
yes.
Stating that sanction of extraordinary leave on loss of pay. They say that on loss of pay, they doesn't want to pay. My entire reputation is.
Where is the 10/9/10/2022 letter?
Court officer responsible.
9/10/22.
9/10/22 is a letter addressed by the.
Where is that letter?
Subsequently, Lordship, this is the
No, it
letter.
is mentioned at para 12.
Payment of salary.
That is not fine. Along with counter. Para 12 jadu.
Yes, sir.
Please read.
Submitted that district education officer Mehboob was addressed a letter to the respondent about that is director of school
To
education.
pass necessary orders in the matter of
Extraordinary leave period.
from so and so to so and so for consideration of payment of salary.
Salary, right, interest.
Where is that letter? So not fine. Yes, 32 pieces. Use of counter use quote. And second letter, 2/1/2018. నేను చెప్పినా కదా చూసేది. Yes. For release of salary for leave period. Where is the order of this court? Have you filed contempt?
Yes, we have filed contempt.
What happened to that?
Contempt was allowed once my retirement benefits for release. They calculated up to my date of retirement entirely. They were not calculated the due period. They calculated this 491 days
As on duty.
as a duty. Now they do, now 19/9/2023 letter, which was recently produced.
Yes.
They say that sanction of restorative on loss of pay. For pension, for retirement benefits, everything they calculate.
Santosh, what do you want now?
Clarification. But need to clarify.
Clarification from whom? GP. Read that letter. Yes.
Sanction extraordinary leave on loss of pay for the period from dated 28/4/2011 to 31/8/2011.
Regarding that particular period, any proceedings were issued by the respondent regarding the settlement of that particular period?
No proceedings for that reason, we have filed the petition for payment of salary.
Yes, this is the only basis. 32 letter, page 32 is the. Yes. That letter is addressed to Director of School Education.
Yes.
For payment of salary only. Then? Yes. Yes.
To the letter starts. 34 the operative one.
Yes.
Second paragraph. I submit that the petitioner was not attended duties from September 2010, which was communicated to the DO Mahbubad by the correspondent of TSHC and further even communicated to the court of subcommittee. The concerned correspondent has sanctioned half pay leave from dated so and so. And the last time what my learned said is now earn leave at credit from so extraordinary leave on loss of pay from 24/8/2011 to 31/8/2012. That is 491 days. Last four.
Yes. Yes.
So that is also loss of pay on the and the same has now been communicated by me.
Yes, though it is referred as subject column, it is stated as upper release of salary for leave period. Here also they stated that treated as the leave period.
Extraordinary versus loss of pay.
Loss of pay.
You have the orders.
What is the order of this court in writ?
In this report.
Yes. No, earlier.
Earlier they directed me, the transfer orders were set aside. That is there along with the report.
1 second. Is there any interim order in this case?
In this case, there was an interim order for directing me to release all the retirement benefits that were released as they.
Without settling that particular period.
Oh, that is also included for retirement benefits.
Where is that interim order? Yes. Yes, well. I got it. Having regard to said submission, the petitioner is directed to present himself with an application before the correspondent sixth respondent hearing on 22/2/2016 along with service record, and the sixth respondent shall process the request of the petitioner on release of pension and all other benefits to which the petitioner is entitled to, including payment of salary for the period till he retired from service, and an appropriate decision as warranted shall be taken within a period of 6 weeks from the submission of the application on the date of his appearance. Yes.
We have complained that. But
No, including.
now the government body include this 491.
What is the date of transfer?
Yeah. On 10/1/2009.
10/1/2009. Yes.
Later on, I filed a writ petition.
Yes. What is that writ number?
1/7/2009.
Yes.
The writ petition was passed orders in my favor on 9/7/2010.
Yes.
Subsequently, Lordship.
Any interim was there in the writ?
It was set aside. Transfer order is set aside.
No interim order, but finally it was set aside.
It was set aside.
Yes.
Then the Lordship immediately petitioner went before the school which he has to join. They did not allow because already somebody is working. Then the person who is working in the Chandrasekhar, he filed a writ petition.
What is the writ number?
19727 of 2010, Lordship.
197.
of 2010.
Yes.
And the first respondent, Lordship, in that he pursuant to that order granted was continuing. I was not allowed to join.
What is the date of order in that writ?
Lordship. And the suspension on 14/6/2010, Lordship.
14/6/2010. That is prior to your final order.
Consequential proceedings says 14/7/05. The petition was still pending. Lordship. Subsequently, then I filed this writ petition.
When was he retired from service?
With petitioner, Lordship.
Yes.
Petitioner retired on service, Lordship, in 31st August 2012.
So till date of retirement he has not been joined anywhere.
So he was not allowed to join. They have to allow him to join, Lordship.
What is the order? Come to what is the WP order?
Lordship, your Lordship gets the
Page 12.
Page 8, Lordship. Page 12 is the order, Lordship.
Yes.
Under this, writ petition is disposed of prior to third respondent to grant temporary ratification of the order, transferring the petitioner from Kottagudem to Dornakal, Warangal for purpose of drawing salary of the petition and arrange for payment of salary.
1 second. Yes, writ petition is read.
Page 14, Lordship.
Yes, read.
Under these circumstances, this petition is disposed of.
Please read entire order.
The writ petition is for seeking the manual declaring the action of the respondent, transferring the petitioner working in specific post of grantee aid to another post available on another unit as arbitrary illegal to the rules prescribed under the institution consequential to quash the impugned order related to it. It appears that petitioner was working as school assistant at Central Andrews was transferred to Dornakal in Warangal district again as another vacancy. It is necessary.
There is no necessity.
There is no necessity going into all the details. The fact that the petitioner was working as school assistant at Central Andrews and he was transferred to Dornakal in Warangal district to a school which is under management of third respondent is not in dispute. The school is located in different district. Rules do not permit for transferring such person from one district to another district until unless permission is obtained from competent authority. In this case, admittedly, no permission is obtained by third respondent before passing the impugned order. However, after filing the writ petition, since no stay was granted, petitioner was forced to join Dornakal and is working as such in an aided post at Dornakal. The grievance of the petitioner that he is not paid salary from January 2008 till date. It is the case of the respondent dependent that since no approval is granted by them as to transfer order made by the third respondent school, the petition is not entitled to for the salary to be drawn.
1 second. Please read once again. It is the case of the respondent.
It is the case of the respondent department that since no approval is granted by them.
Yes.
As to transfer order made by the third respondent, that is school of it. Petitioner is not entitled for salary to be drawn at Dornakal.
Why? Yes. Please read.
That is the stand taken by the department.
Yes.
And it is for the management to pay the salary.
Yes.
Because without permission they transferred, so the school has to pay. However, it is stated that along with the petitioner, few other teachers were also transferred from Khammam to.
Who is the management means? Second respondent.
Here, in this case, Lordship,
In this
management means the 6th and 7th election.
No, not in this case. In that particular writ petition,
This is for the third respondent.
third response says
Third respondent is the chairman, is the management of the school. Bishop.
yes. However, it is stated that along with the petitioner, few other teachers were also transferred from Khammam to Dornakal and their transfer was ratified
And
and they are being paid salaries. Yes, the next para.
Those circumstances, the petition is disposed of, directing the third respondent to government to grant temporary ratification of the impugned order, transferring the petitioner from Khammam to Dornakal
For the purpose of salary.
notice of drawing salary of the petitioner and link for payment of salary as per the eligibility for the period he worked. Further, since there was no approval granted by the competent authority as to his transfer from Kottagudem to Dona, improved order is liable to be set aside and accordingly set aside. It is directed to permit the petitioner to join the Kottagudem forthwith as school assistant.
Yes, what happened there?
They didn't permit him to join. They say that somebody is working, so you are not permitted to join.
What happened? What happened that 2009 to 97 2010 the payment of salary?
Payment was
That was paid.
that is paid. But later he was not permitted to join in the Kottagudem.
So yes,
Then the management
from 97 2010 to
31/8.
97 2010 to 31/8
So
20.
this is the date of his retirement, 31/8/2012.
What did they say in their counter?
Now they say that he did not come and he joined, no loss, no pay. No work, no work. I'm sorry, no work, no pay. It is their responsibility permitted to join as per the court orders. And now they treat it as extraordinary leave period.
Yes, Pawan.
That was the counter filed by the management. It has to be
Counter one. So counter.
filed by fourth respondent.
Fourth respondent and
Seventh respondent. Seventh respondent. Count back, Your Lordship, in the WPNP 2016.
only government counter is on record.
We also. The counter in contempt.
None. లేదా? Yes, read and pass.
Stand, Your Lordship, was that the relevant period where the extraordinary leave was sanctioned.
No, now you have to answer
Yes, sir. I will
from 97 2010 to 31/8/2012. It is 2 years, 1 month.
the stand, Your Lordship, is that he did not work. Principal left, no work, no pay. Your Lordship, extraordinary loss, Your Lordship, leave on loss of pay is being sanctioned.
Then what is the material?
Yes, sir. Lordship would see that all the proposals written by the DO, the Lordship would kindly take the correspondences, Your Lordship. Lordship would expressly page 32 of the government.
No, council, have you reported to school?
Yes, Lordship.
Where is that material showing? This date of order is 97/2010.
Even in the counter, they admit that I did not.
Yes.
Even
What
in
did
the
they say?
counter, they say that.
Page 33, Your Lordship would see.
33 of writ.
Counterfile by the government because the stand of the corresponding management is evident from the letter to the DO. Page 32, which is the entire basis now. That is not the business. Your Lordship, the proceedings of DO, Your Lordship,
32 of?
counterfile by the government.
Yes. But letter, you are referring to present.
The letter has the facts.
Yes, read.
Page 32, the letter starts. Page 33, Your Lordship. I am permitted to.
No salary, you have to, the institution has to pay the salary. Yes.
Yes, Your Lordship would kindly take.
Yes, one second. Yes, 1 second, Pawan. What material has you have filed relating to regarding whether you are reported to the school or not after disposal of the petition? That is 19/7, after 9/7.
Of 9/7, Lordship. Yes. Exactly. Lordship.
Sridhar Rao is the petitioner.
These are all in the petition. Presentation. Just the banner. Page 15.
Page 15.
Not the- not the-
Stamped or unstamped?
Lordship, this is the government, Lordship. Not the- Page 2010, Lordship.
There is 2010-2011. But order was passed on 9/7/2010.
What about 33?
Please wait. No other material, only representation dated 2010-2011. After 9/7/2010, nothing is filed. There is no material. What is this 31/8/2007 memo, 21 page? That of school education in the reference first and third set is sent proposal for transfer of Ramesh. This is regarding Ramesh, not.
Just have the.
Yes, Pawan. You are referring to page 32, 33.
The submission is
Yes.
because he did not work, he did not join duty and work lordship, that period lordship.
Read the 30 relevant para. Para 3, you are responsible.
That lordship. Page 34 is page 34 after the table, after the table at page 34.
No, page 33 top first para. Please read.
That is about sanction of pension benefits and all that. The relevant para page 34.
Yes, read.
There's a table lordship page below that.
Yes.
Certain that the petitioner was not attended duties from September 2010, which was communicated to the DO Gangapabad by the correspondent, which is Kaskila.
Yes.
So that was correspondence always there, Your Lordship, that he never attended.
Further, even please read further.
And further, even communicated to the report of the subcommittee of the Diocesan Education Committee by references 3rd and 11th cited. So those,
Yes.
always on record that he never worked.
And the concerned correspondent had sanctioned of paying so on. So where is the material regarding non-attendance?
Usually he never attended you. Page 34. The sentence will start. Petitioner was not attended duties from September 2010,
Which was communicated to DU
Yes, Your Lordship. Which was communicated to the DO Gangapabad
by the correspondent. Where is that letter? Where?
Your Lordship, since referred in this thing has a reference number 3rd and 11th. Your Lordship should see the reference 3rd and 11th. So all I'm saying, Your Lordship, it's a matter of record where correspondence were exchanged between the correspondent DO that he did not attend unless his own representation also not of the original date. Even now, subject to what my learners has standing. It's not his case that he worked and is not being paid. Admitted fact is he never worked.
Yes.
So as such, he's not.
But his contention is as per the orders of this court in WP number earlier WP 1887. He should have reported to the.
First, in fact, there was some issue about those things. He did not come back to the institution, and when he did not work,
What is the prayer thought in the petition?
No, that is not the case. I was not allowed.
No, where is the material?
Even page 27.
Yes.
They want to settle my salary, but they did not.
Page 27 of.
Petition.
Yes.
It was in the copy of the government memo dated 14/6/2010. Yes, the correspondent central is requested to cancel the transfer orders of case Sridhar Rao, Central who was transferred to DD High School, Warangal district, and also relieved M.H. Chandrasekhar aided Kottagudi with instruction to report at DD High School. He requested to submit a salary bill for case Sridhar Rao, Central High School, duly obtaining the attendance certificate for the period he worked. We went. That is the reason they have given us. It is not that we did not attend. They never permitted me to join. That is the case. Because M.H. Chandrasekhar Rao is working in that place here. They did not relieve him. And making me join. Now they say that I did not work, I did not come forward. This is the first
So
time.
there is no material.
You
have to establish that even after reporting the school, they were not permitted. No, where is that?
Even after reporting school, they did not permit.
Where is that material? This is with regard to salary, payment of salary for the worker period, that is as recorded in restitution order. Is request to submit. And also review. Whether you request to submit.
Only make one number.
In consequence to writ order,
We'll make one number. Document C is prayer. His prayer was on inaction of the respondents. Now, basing on the material, an order is passed. And all here, yes, sir, because the prayer is only inaction of the authorities in considering. Now, consideration has been done and some order has been passed, partly allowing his claim, partly rejecting his claim. Let him, Rashmi closes his petition. We're liberty to challenge that, where he can plead appropriately, then we will also have an occasion to rebut. Because his prayer, now he cannot go beyond the prayer. Prayer was the lordship only inaction. Now the respondents have considered this case and passed an order, which my learned chief is placed on record. Now, if he has any grievance against that proceeding, let him institute a fresh petition, the lordship, with appropriate pleading. Then we'll have material to rebut it, lordship. Now, lordship, in his prayer, there is only inaction.
inaction of the respondent not releasing the salary to the petitioner since September 2010 to till the date of till date by implementing PRC 2019 as per the education rules.
Order has been passed by the government.
The respond to consequently direct respond to release the salary from September 2010 to date to retirement, not retirement, date to the petitioner by implementing PRC 2009-10.
I filed in July 2012 itself. Prior to my retirement. Oh. But if your lordship sees that I was running a case that Monday lordship, I'll give the producer the representations that made by the petition which is issued by them. So that it can clarify the court. That is the case. Just give me a
So you have to establish that even though you are reported to the school, and also it is your duty to issue in person to the interim orders of this court. It is the duty of the college school
to issue me orders of the joining orders. They have not issued. That is also it. Now that is the reason I just want to act on Monday and produce all the.
Yes, you have to answer that.
Transfer time instead of which day. Weekend is 1 week's time. I'll produce those records. I'll produce the original record of the
What has happened, lordship, for a minute?
Yes.
When the interim order that they did not pay my salaries and their retirement benefits, the court has called for they are unable to produce the record. For that reason only, lordship.
And also there is a direction to pay the salary till retirement.
Till retirement.
Pursuant to which they filed the contempt. Contempt was closed, recording that lordship, whatever they wanted, that I base all
Milord, I am appearing on behalf of the petitioner and I am an online Milord.
Yes.
Milord, the petitioner is a working journalist, Milord, and the issue is recovery of due wages, Milord.
Counter
Milord,
filed?
no counter was filed, Milord.
Oh, yes.
If they are ready, I am ready, Milord.
Yes, yes. I have an idea what. Yes, sir. Proceed.
I would like to present date-wise events, Milord.
Yes.
Milord, on
Where is the idea?
the petitioner,
Page 13.
Milord, may I go, Milord?
Yes.
Milord, the petitioner is a working journalist, Milord.
Yes.
On 14/5/1986, Milord, he was appointed as sub-editor, Milord. Milord,
Yes.
kindly go to the page number 88, Milord. Page number 88, Milord.
One second.
Page number 88 is the appointment order of the petitioner, Milord. On 14/5/1986, he was appointed as the sub-editor in Andhra Printers Limited, Vijayawada, Milord.
Please wait. Please wait. Yes, 88. Yes, sir.
1980, page number 88, date of appointment is 14/5/1986, Milord. But subsequently, Milord, page number 97, Milord. Page number 97.
Page 97. 1 second.
During for the years 1995 and 96, Milad, elections to the working journalist of Hyderabad unit of Andhra Pradesh working journalist was held, Milad, wherein for the year 1995 and 96, my petitioner was appointed as
Page 97. Council.
my
You are
lord.
referring to Page 97. What is that 97 letter?
The 1997 letter is the letter given by the Andhra Pradesh Union of Working Journalists, Milad, wherein the petitioner was shown as the elected president of the Hyderabad Union of Journalists, Milad, which is a unit of Andhra Pradesh Union of Working Journalists, Milad. For the years 1995-96, he was the president of the Hyderabad Union of Working Journalists, Milad, and he continued up to 1999 in the said post, Milad. That is the letter given by the Andhra Pradesh Union of Working Journalists, Milad.
Yes.
And moreover, Milad, page number 68, Milad.
Yes.
Page number 68.
Yes.
Milad, page number 68 is the chief examination of witness number 2, Milad, who is B. Radhakrishna. He is the manager of the Andhra Pradesh Union of Working Journalists, Milad.
Yes.
He has categorically held that their association, their union has issued the letter wherein the petitioner was appointed as the president of Hyderabad Working Union Journalist for the years 95 and 96, Milad. That's why the letter was given and it was supported by the evidence of the witness number 2, Milad.
Yes.
Milad, as he is the president or being the office bearer of the union, Milad, he was a protected employee, Milad, as per the Section 2F of the Working Journalist Act.
Yes.
Milad, as per Section 3 of the Working Journalist Act, Milad, ID Act provisions are applicable to the Working Journalist Act, Milad. Section 3, Milad, Section 3 of the Working Journalist Act, which says that the provisions of Section ID Act 1947 apply to the Working Journalist, Milad.
Yes.
As per the Section 33(3), Milad, any office bearer, Section 33(3) of the ID Act 1947,
Have you filed
any,
that?
my lord,
Yes, 33(3). Yes, read.
33 is the protected employee definition is there, Milad. As
Yes.
such, my petitioner being the president of the Hyderabad Working Journalist Union, Milad, he is a protected employee and he is not required to be shifted or transferred to any place from his working place, Milad. That is the minimum protection given to the office bearers of the unions, Milad. That is in the Schedule 5. That is in the Schedule 5 of the ID Act, Milad. 5F. 5F and 4F. Schedule 5 of the ID Act, Milad.
Council.
My lord.
There is is under which provision the journalist got protection?
ID Act, Milad. ID Act has some schedules, Milad. ID Act has the schedules, Milad.
Yes.
5th schedule, Milad.
Schedule. Read.
ID Act some schedules, Milad, annexed to the Act.
Read, sir. 5th schedule. Read.
5th schedule, Milad. 5th schedule.
ID Act. Council, please read relevant portion.
Yes, Milad. This is the 5th schedule, Milad. I wanted to bring to the notice of this Honorable Court, Milad, Section Rule 4F, Milad, and 5F, Milad. 4F, discharge of office bearers or active members of the trade union on account of their trade union activities. Next one, 5th, sir, to discharge or dismiss workmen by way of victimization, not in good faith, but in culpable exercise of the employer's rights by falsely implicating workmen in criminal case on false charges or patently false reasons, untrue or trumped up allegations of absence without leave in utter disregard of principles of natural justice in the conduct of domestic. These are all the activities which is not to be imposed on the office bearers, Milad. That is in the Schedule 5th, Milad. Milad, now my next event is, Milad.
Please wait.
Page number 108, Milad. Page number 108. Milad, being the president of the Hyderabad Working Journalist, Milad, my petitioner has involved in the issues of the employees of the Udayam newspaper, Milad, wherein the Udayam newspaper was going to announce its lockout, Milad. And so, being the president, he has taken up and showed some interest in the welfare of the working journalist of the Udayam newspapers, Milad. Page number 108 is the letter, Milad. being the president of the Hyderabad Working, he made correspondence with the government, my lord, page number 108, 109 and 110, my lord. This clearly shows that, my lord, this is the executed document, my lord, marked before the ID labor court also, my lord. This clearly indicates that my petitioner, being the president, involved in the issues of the employees of the Udayam newspaper for their interest.
Now, what is the issue before tribunal?
The issue is not being a president, he has to take care of the interest of all the working journalists who are working in the Hyderabad, my lord. My petitioner working in the Andhra Jyoti, my lord, that is a different issue. When this is the Udayam newspaper, my lord, this is a different organization. Even though being the Hyderabad Association president, my lord, he has to take up the causes of the interest of the Udayam newspapers also. That's why he has engaged in the activities of the unions of the Udayam newspaper also, my lord, to take up the interest of the working journalist of the Uday newspaper.
Yes.
Aggrieved by the intervention of the petitioner, the management of the Udaya newspaper has brought undue influence and pressure on the management of the Andhra printers, my lord. As a result, my lord, page number 98, my lord. Page number 98.
Yes.
On 3/3/1997,
Yes.
abruptly, the petitioner was transferred from Hyderabad to Delhi, my lord,
Read.
which is not a page number 98, my lord, sorry, 98, my lord. Page number 98 is the transfer orders, my lord. Petitioner was abruptly transferred from Hyderabad to Delhi, my lord, which is a non-publication area, and there is no post of subeditor in Delhi, my lord.
Please read
This
that
is the my lord, this is the admitted fact by the MW1 in his evidence also, my lord. I will mark that line also, my lord. My lord, this transfer order was not served to the petitioner, my lord, because it was already requested before the at the time of trial also to produce whether the signature of the petitioner was taken as a receipt of service of this transfer orders, my lord. It was not produced, my lord. My lord, immediately after knowing that he was going to transfer to some other place, my lord, the petitioner has approached the Honorable City Civil Court, Hyderabad, my lord, page number 89, my lord. Approached the City Civil Court, my lord, by OS number 829 of 1997 and got the status quo orders against the transferring of petitioner from Hyderabad to Delhi, my lord, page number 89, my lord. Page number 89, my lord. This is the status quo orders, my lord, which was initially granted up to 19/3/1997, my lord. Subsequently, it was made absolute till the case was disposed of, my lord, as dismissal for default. That was the admitted fact, my lord. After that, my lord, 1997, my lord, on 23/1997, the orders were made absolute, my lord. Immediately, the petitioner has approached the management and by way of representation and submitted his representation, my lord. Made page number 118, my lord, for reference, 118, my lord.
Sir, we'll post next physically.
My lord, this is the letter produced by the, my lord, this is.
Also, we are posting the matter next week on 16/11. Come physically and argue the case. Yes.
Very much obliged, my lord. Very much obliged.
This one. See, reference is not. You understand that?
Item 50, AJ1, GP for Women Development.
Tickets to have it in the district in bundle. So then the priority be about.
She deals with the notification pertaining to the year 2013. The series of the petition is given, 15 marks were weightage marks were given to supervisor, and that particular marks were no weightage was given to petitioners who are unemployed persons. According to my inspection, no counsels filed the case. The recruitment process was over. There was no information.
We'll appeal the next week.
Where is the notification? Other, as per the notification, whether they are entitled or Court of
It was
Study.
issued only granting service weightage to supervisors.
15%.
Get instructions with postmaster.
15% weightage was given only to supervisors.
Only.
I think that the petition is fine. Saying that weightage also should be extended to us. There was no intermodal at the time of admission. Now we are in 2023.
Yes, what remains in the petition? You are seeking to extend that benefit which was given to superintendent. What is your legal right to ask that? There is no interim order.
The contract plus
Like so time matter has become.
Yes, declaring the action of first responder and issuing GO 12 for women, children, disabled, awarding 15% of service weightage to the contract supervisors and the total marks without giving any service weightage marks to the Anganwadi workers. Consequent as the respondents to award 15% weightage marks to the petitioner and evaluate the honor scripts and appoint the petitioner to the extension officer grade 2. We record the statement when the matter is taken up for hearing, Mr. Venkatra, Mr. Jagan comes up in the prisoner duty effect the time cause the petition does not survive for us. They are dismissing your petition. Why? What is it? Even then, get instruction 230.
you got a strictest.
ఏం లేదు దాంట్లో నెక్స్ట్ చేసినా అదే ఇప్పుడు చేసినా అదే మ్యాచ్ టేకన్ ఆఫ్ ఏదో మిస్టర్ వెంకట్రా వి ఆర్ డిస్మిసింగ్ కౌన్సిల్ అపేరింగ్ ఫర్ ద we are dismissing as infructuous.
No, this is
16 is different. 16 is different.
16 is yours. Yes, sir. Okay, we don't have conflict. Review order, fresh engagement. They are relying on judgment of this court. Courts are marked, but a review, order in review, modifying the punishment of removal to that of, let's say the termination order and obtain fresh contract service agreement. No. Whereas the case, it is the case irregular attendance and party even after termination one time did not improve. However, purely on humanitarian grounds, another chance is given and sets aside the termination order given by the depot manager. He is re-engaged into service as contract driver afresh and posted to Banswara depot. Epandi.
And they have it in the next week we'll argue.
Look, sir, argument just same.
Next week, I don't have point.
This one change. Will give our pardon. They are relying on this court judgment. Is the Honorable Justice Subhash Court officer. Please give a copy to counsel. Venkatra, they are relying on this court judgment. Okay. Take off. Do that.
Item 30, A.K. Jayaprakash Rao, Nandiyam Krishna.
Yes.
The report is not well. But only 10 days.
Yes. Post on Tuesday. I request the respondent post on Tuesday. The same cap.
Item 18. V. Narasimha, Garden Srinivas, Ravindra and
Count is filed, count is there.
Proceedings not stating that we have a certain benefits. That DSFP of
10/7/2023. List on 18/7. 19/7 at request of the standing council for the respondents. Post on 25/7. No further adjournment will be granted. 25/7. Today also the standing council for response seek time for getting instructions and to proceed with the matter. Post on 7/8. Finally, no further adjournment will be granted. On 7/8 onwards, this is listed before us. I request the standing council. Post on 21/8 to file counter. None appeared for the respondents. 21/8. 23/8. None appeared for the respondent. 28/8. None appeared for the respondents. Post for orders. 5/9. It requests the standing council for filing of counter. Post on 29. 29. It requests the standing council for the respondents for filing of counter. Post on 4/10. 4/10. It requests the standing council. Post on 11/10. 11/10. It requests the standing council. Post after Dasara for filing of counter. 30 October. It requests the standing council for response to post on 6/11 for filing of counter. 7/11. None appears. 7 not 7. 7/11. None appears for the respondents. Post on 9/11. ఇది చదివింది ఏది మీకు అర్థం కాలేదా? $10,000 cost. What is this? How many attendments? July, August, September, October. Weekly once it is being. What is the issue, madam? Yes. Yes. Yes.
Review must not any order by the date is not come to the right hand, take to the right hand.
మెటీరియల్ ఏమీ వేయలేదండి. జస్ట్ అడ్వకేట్ నోటీస్ అలాంగ్ విత్ పోస్ట్ ఎగ్నాలజ్మెంట్ వకాలత్.
In the meantime, petitioner reached with the exact superannuation. He made a representation to the respondent.
Where is the representation? Where is your representation?
He got issuing advocate notice.
Just now you said representation.
He's only very question.
Read your letter. Advocate notice. Read, చదవండి. Para 2.
Subsequently, service for regular 5889. If the cancel balance of hospitals, he has sustainably removed from service by second of calling and move on answers by the other related sources. Thereafter, he had prepared an appeal before the appellate authority, who proposed to reject the same by the other related sources. We will have prepared a petition within time. He went before the date before first of June, but till the day it had not seen the light of the day. He further states that relevant he approached the office of first of June to know the results of his petition. It is being under consideration. The last year, the result petition the presentation before the first of June will still a delay. Disposal of his that has been suffering like anything as he is unable to move further in this regard. Therefore, the same is arbitrary.
Yes, pass out. Get instruction. Yes, sir.
Yes, PM and CCS.
Madam,
Shooting bunch, new W benefits.
Madam,
For removed employees, cannot pay.
Yes, madam.
that gratuity was not paid, madam. The leave encashment was not paid, madam. Last month's salary was.
You are not stated in your letter. Nothing is stated, just you asked.
Madam,
Have you stated in your affidavit what was paid, what was not paid?
after sending his requisition, they paid some basic salary.
Where is that? Proceedings are there.
No proceedings, they are not served any proceedings, madam, just now, my friend. Possibly your lordship, madam. Came to know.
This letter, 29/7/2023.
Madam, yes, amount 91,000 got paid, madam.
You may see, there are receipts also, issued by petition, each page.
Madam, PF amount,
Check numbers are.
Madam, what is your complaint? They are paid.
madam, PF amount 91,000 was paid, madam. SPRS amount 42,000 was paid, madam. EPF amount 999 rupees, this month paid, madam.
Please go through this letter and inform to this court. 230.
Madam, lesson file counter method I will find, madam.
Complaint అమ్మా నీకు అన్ని ఇచ్చారు కదా దాంట్లో ఇంకా
Madam, gratuity was not paid, madam.
గ్రాట్యుటీ వాట్
Unemployed errand police salary was not paid, madam. Last working day salary was not paid, madam. SPC was not paid, madam. TCS was not paid.
TCS was paid.
లాస్ట్ వర్కింగ్ డే సాలరీ హౌ యు ఆర్ ఎంటైటిల్ యు ఆర్
Madam, I
Removed
was-
employee, they can't claim.
Yes, madam. I was removed in 25th, madam. I'm entitled for 25 days salary, madam.
Case in file count.
యు ప్లీజ్
Is fairly covered, madam. Lesson file from.
కవర్డ్ బై విత్ జడ్జ్మెంట్
Recent judgment from the other. Effective, madam. Report judgment. Madam, lesson file found to madam, I will madam.
Monday. Request the respondent to file counter as a last chance. Post on 16/11. It is made clear that the matter will be decided based on available facts. Failing which the matter will be decided on based on the available. There is no material. You have not filed single paper.
That has been got on because they have not, they have, surely amount they kept silent.
After filing this requisition only, they said.
File an affidavit. What was received, what was not received. You also file an affidavit. Yes.
This file madam, found to madam, file madam.
Otherwise, we will close the requisition on that day. I am making very clear because both people are.
Madam, if they file found to madam, I'm from the missing what not paid, I will find a reply letter.
Yes, next.
Item 19, please take it out. Madam Secretary.
Then, this one, this one. Yes, ma'am.
So if you use certain hours, so they are not relating to service benefits, also the monthly benefits. And the dentist for the year 2050,000 by lordships.
Counter, not file. Counter, madam. Yes, make it. Yes, proceed.
My lordship, he was, it was appointed as private lordships. In the year 1987, and he was removed from the service in the year 97.
Yes.
My lordships. For the allegation stating that he was absent leave for the period of 16 days, my lordships. For which the disciplinary proceedings were initiated.
23176 of 2009. Where is that order? 23176.
Page number 20, my lordships.
21, yes. What was the direction? But accordingly, petition is granted the relief of continuity of service only for the purpose of granting retirement benefits by calculating notional increments when confirming the award in all other respects. Thus, the labor code award is modified to the above extent. Yes.
Lordships, they did not even pay the service benefits for the period of 10 years, 40 years on my lordships. The genius is that only they calculate the benefits for the period what he has given the services period, that is from 2019 to 2012, my lordships.
It shall be interim direction to the respondents to pay retirement benefits of the petitioner in terms of the order passed by this court in WP number 23176 of 2009 dated 12/12/2012, which in a period of 2 months from the date of receipt of the copy of this order. This order is compliant?
Yes, no complaint.
But my lordship, the amount what they paid is very, that is for the services, what he put on my lordships. Did not pay the entire amount for the period for 2006 to 2000, not the wages have not been paid.
No, please read the prayer in writ petition. Don't go beyond the prayer.
For the reasons written, the simple say that this government told me this would follow for the cost for the period. It was the action particular the nature of the impact. And during the inaction of respondents hearing in not releasing the service benefits as per the orders stated working.
Now come to the order. And also not paying the wages for the period from 20 October 2006 to 20 May 2009 as argued. What do you say about this payment of salary for?
The order was brought at page 26. Granting the relief of monthly of service only for purpose of granting the retirement benefits
Yes.
and calculating notional increments.
Yes.
Notional increments. Approximately or counter.
1 second.
Or counter para 7.
Yes.
Para 7.
Read.
He submitted that as per the interim order of this honorable court in the present expedition, the respondent corporation paid the following difference of terminal benefits amount which is fixed in Act 6,423 the petitioner as per the eligibility duly allowing the notional increments.
Yes.
So we have paid.
You are disputing this para.
Yes,
This. Have you filed any reply?
asking my family still time gratis time will file or reply.
No, we'll 2015 counter, madam. We'll close the requisition with.
Tuesday, my lordships. Tuesday.
Pass over gate.
This is what they have to do for labor code. They are disputing the amounts of computed
Yes.
in terms of money.
Pass over.
They see to last year.
Pass over 230. We'll close the requisition.
Please, that's ready and proper ready.
Yes. Yes, madam. What is the issue?
Instructions are saying the gratuity amounts are not paid.
You file counter or not? You have filed counter?
No, ma'am. But
Counter is filed by. Counter is on record.
on the file, it had give instruction saying the amounts have been paid.
Yes, counsel.
Classification, I approve this matter of loss. Which is seeking the law. First, on delay payment, delay in the benefits matter. And in fact, a lot of India and going to file a application memo also loss. So my senior, I'm an instruction about my seniors better this in the argue this matter. Because immediately after retirement, immediately he submitted his pension papers to the authorities. My representations also good.
How much delay is there?
Lordship,
What is the date of retirement?
presentation.
1 second. When was he retired from service?
Lordship,
30 June 2014, date of retirement. He has handed over the charge only on 6/8/2014. After he retired from services on 30 June 2014. This itself shows that the petitioner was intentionally trying to mislead this court. He handed over the charge of Dammapeta Mandal to Jagdishwar Reddy on 24/7/2014 and further charges of MSP operations of the Adoni Center only on 6/8/2014 to 3. Udayadhir Reddy. And the sponsor instructed the petitioner by letter dated 27/6/2014 to hand over the charges to K.V. Sudhakar Rao, Deputy Manager, Kurnool, on his superannuation third date.
Lord, I have seen the part of it away. The indications are baseless for what they have
The petitioner has not handed over the charge contrary to the letter dated so and so.
Absolutely wrong.
Then you have not filed any reply. This counter is filed long back, that is in 4/2/2016.
That is the reason my senior will argue this time.
How long?
Last occasion I argued a lot, but because of the
Why
respondent.
was it urgent?
Because of respondent, a lot, none appeared about the respondent last occasion.
Absence. In their absence, you have argued the case. What is it? However, he has not reported back as directed to headquarters since the period of so and so treated absence last 2 months, and salary of the particular month was not recommended for payment. He has not informed whereabouts.
No departmental inquiry, no charge papers issued, no departmental inquiry is conducted. Nothing is on record except this vague allegation that where in the contract. If that is true, my lord, we can conduct inquiry and impose punishment. But the thing is,
When was gratuity was paid?
because after filing contempt, my lord,
What is the date of payment of rent? Contempt in which writ petition?
in this petition, contempt is filed, my lord. After contempt, personal appearance is ordered, then they.
What is the date of interim order here? There shall be interim direction as paid for. That is on 3/12/2014. 3/12, not 3/12. 30/12, that is January 1st, 15. Yes, madam.
They're on record, but then they return the file.
Return to whom? No, you are not appearing. Contempt is closed or still it is? What happened to contempt? Sorry, verify. What is the contempt number? AC number. ఇది చేయండి, నెట్ ఓపెన్ చేయండి. WP నెంబర్ 3947/14.
Yes.
స్టేటస్ సీసీ కనెక్టెడ్ గా చూపించేస్తున్నాను. కనెక్టెడ్ సీసీ ఏం చూపించట్లేదు.
So now you have received the gratuity amount.
This funny, my lord, lordship. The questions are unable to answer. This is funny. It on Monday, my lord. On the adjournment,
So what happened to that CC?
Yes,
You've been informed the amount has been paid.
Tuesday, what request to the petitioner to get instructions post on Tuesday for orders.
yes, yeah, review of that.
Item 21. Yes, Prabha sir.
Same, already visited. Yes. What is the issue?
Back cases to not the issue, it means back.
17B. Wages are paid. It has been reinstated. We'll call the report. Subject to the petitioner company reinstating the third respond workman immediately to duty subject to complying with the provisions of 17B of the Industrial Dispute Act and subject further to depositing 5,000 towards litigation expenses liable to be incurred by third respond, which shall be stay of all further proceedings. Is ready. Is ready.
The person needs to be closed up, but this is active inspection.
Password. It is
That means senior is also not. This company will not active. That's the issue.
already in the list from
Only Tuesday you'll ask the next working day.
37.
Yes, yes. Only
Not ending 37. It's coming. Yeah, 37 onwards. 37, 18, 16, 8, 17, 8, 24, 8, 28, 8. What is this?
we apologize.
4, 9, 11, 9. Every time I will.
Yes, sir. Everybody have taken that time.
At request of the respond number 3. You list on 24/7. You do not list on 18 at request of the respond number 2. Same council. At request of the petitioner council. None appear with the petitioner on 17/8. At request of the petitioner. We'll close the petition, sir. Get
It is
in.
not possible.
May pass. 230. Yes.
Item 22. M. Shalini. Difficult registration. Difficult services.
What was the tribunal order? Back way is also awarded. Get instructions. No, otherwise next week, post next week. Because Wednesday. Or same day. Today is Thursday. 10, 16. At request of the petitioner to get instruction. Otherwise, argue the case. Yes.
Item 22. M. Shalini.
Yes, ma'am.
Case where member originally the employees of the industry may not who are the lateral professors, if we retire at the age of 60 years, and pension is to be paid on the last paid draw at the age of 8 years. By which may not be 2 years, don't valid intervene, they find repetitions and repetitions were allowed, we went up to SLP, and you were 246 was issued,
Yes.
But may not these efforts and orders may not, the petitioners who have filed these cases are not benefited much, because from the date of the retirement, the benefit is not given. Prospective effect, the due is given prospective effect. That is the question here, my lord. In fact, there are also with the fees pending on this issue, my lord. to verify the present status about that.
Count is fine. Yes.
Have the records about that.
Any grievances, my lord? Zero is given effect with the
Prospective.
Originally, these matters like doctors.
Have you filed any judgment?
At the stage of the original writ petition, my lord, so documents have taken place, my lord. That is at page 17, my lord.
70.
17.
Yes.
Then post the arguments in this case, my lord, all those things are submitted to the
Read relevant para. Following the same. So as a covered matter, these are disposed of.
Originally, my lord, when arguments have taken place, my lord, it went my lord, was confirmed in the appeal number page 20, my lord.
246 GO. Dated 2010-2008. You are challenging in 2011.
Because, my lord, the EO was given implementation only in the year 2009, my lord, though it is 2008, my lord, these petitions were given benefit in the year 2009.
So what is the?
That the association
Please read the GO. Read the GO.
is page, my lord,
Amendment to the yes. Government, after careful examination of the matter, have accepted the request of the AP Federation of University Teachers Association.
the age of 50 years instead of 58 years, and hereby issue the following amendments to the pension rules for university teachers 1992, issued in GOMS number 277, Education Department, dated 2nd December 1993.
This is amendment to the earlier GO 277. Amendment to yes.
In respect of teachers who retired after 1/4/1992, the calculation of pension shall be allowed at the age of 60 years with monetary benefits from the date of issue of this order.
Yes. What is the date of retirement of the prisoners?
Petitioners, my lord, after 1992. But my lord, erroneously, my lord, the benefit was not given from the date of the retirement. Benefit was given from the date of the GO, my lord. That is the grievance, my lord. My difficulty now is, my lord, all the petitioners at the stage of original writ petition, they were very curious.
You are agreed by the which portion?
Then
3-1 itself. In respect of the teachers who retired after 1/4/1992, the calculation of pension shall be allowed at the age of 60 years with monetary benefits from the date of this issue of this order.
yes. The prayer sought in this writ petition is, my lord,
In giving a retrospective. Prospective.
I tried to contact the petitioners, my lord, at that stage, my lord, after retirement, they were very eager and very seriously they supported me, my lord. Thereafter, my lord, these petitions became
No entry model, nothing.
my lord.
In fact, the policy decisions not to interpret for not giving a prospective effect and seeking for a retrospective effect for not, those are directions can be passed.
And,
Yes,
I'm
madam.
able to place my lay my hands on the multiple judgment, my lord. I'm not sure about it, my lord, but there are certain orders passed in the writ appeal, my lord.
When the matter is taken up for consideration, learned counsel for the petition submitted that the issue involved in the writ petition is covered by the judgment of the division bench of this court. Division bench.
That's what, my lord.
And short adjournment to produce the copy of the order. This is on 24/3/2023.
Since then, my lord, I'm trying to contact these all the petitioners, my lord.
The request post on 28/7 is on 24/7. In the meanwhile, the learned government petitioner, counsel for petitioner is directed to furnish a copy of the order. Get that copy of the directed to print the name of GP Services one in place of higher education and Rishi
My
Kumar.
lord, like my friend representing university may also verify, my lord.
What is the petition number? You don't know that.
We do not have a other than petition records has to be supplied for the.
Petitioner said the time of filing this petition, my lord, he was 72 years old, my lord.
Please get the, otherwise we'll close the petition because unnecessary.
2 weeks time we can add.
14, 15. 2 days. 4 days, yes. It requests the petitioner to get instructions post on 15/11.
Like,
For orders, it's close the petition.
item 23. Check the police remarks.
Yes,
Typical mental health and family. Correct.
yes, madam. What is the issue, madam?
Failing to take action against respondent number 3 in orderly terminating the service of petitioner is not. So, Lordship, petitioner counsel also start the optimization. They are not representing from the case.
Order is filed.
Yes, Lord.
Filed.
Yes,
Counter the madam. We are appealing for R3. We are appealing for R3.
So, Lordship, counsel is fine from 25/8/2011.
None appears for the petitioner.
The Lordship, may I make the submission? The Lordship, this writ petition has to be discussed on the ground that there is an alternative remedy available to the petitioner, Your Lordship, but even then he has removed the jurisdiction article from the
Yes, none appear for the petitioner. Post next week for dismissal.
Item 24. Yes, Sudhir. That 12 months. Please, Suresh.
Yes, madam. This is yesterday's matter. What is, madam? Yet request, yet your request only. This is matter posted today. On 8/11, yesterday only. It request of the petitioner post on 9/11/2023. Then we passed over. 14. The request of the petitioner post on 14.
Item 26. R. Sujan Kumar. GP per Panchayat Branch. R. Patnarekha.
Lord, I am appearing for fifth respondent. I filed my counter, Lord. Lord, I am sailing with the petitioners. Lord,
Mr. Kocha, show your face.
Lord, fifth respondent, I am appearing, Lord.
Yes. What is the issue?
Management, I filed my detailed counter, my Lord. I am sailing with the petitioner. I am supporting the case of the petitioner. That, my Lord, all the selected candidates were not paying any salaries, my Lord. They are working without any salaries.
26.
And they are duly, by following due process of law, they have been selected.
Kocha, item 25 is already adjourned. 14.
I'm so sorry, my Lord. I am
14.
not informed.
Posted on 14/11. Yes.
Obliged. Obliged.
Item 26. R. Sujan Kumar. GP per Panchayat Branch.
One not pay for the petition post. Confusing. Counter file. Counter that one. Madam, counter is there or not? Counter is not in our bundle. File in the registry. Inform to her. Counter is not in our bundle. Next Thursday, 1 weekend. Thursday, madam. Yes.
Item 27, GVCRT, V. Umadevi, P. Lakshmi.
My lord, 1 week time may be granted, my lord. Bundle is not raiseful, my lord. Bundle.
In this case, we filed still many papers by their memo method on 7/11/2023. Also, petition number 4 filed a memo for repair of this request to be got a plan. First, we direct the office to
7/11.
based on 21/9/2023, we filed a draft on behalf of petition number 4.
What is the USR number?
That is 93576 of 2020.
93576 of 2023. Dated
Dated 21/9/2020.
21/9.
Yes. The another method on 7/11/2023, we filed additional meeting papers by way of memo method. That is VSR number 109905 2020.
109905.
Dated 7/11/2020.
Yes, a request was responded post on 16th and registry is directed to put up the withdrawal letter by USR number 93576 of 2023 dated 21/9/2023 and a memo by USR number, memo filed by the petitioner by USR number 109905 of 2023 dated 7/11/20. Post on 16th of.
Item 28, K. Jayprakash Rao, Dum Chambers.
He joined the service of Disciplinary as casual labor on 21st August 1991. And he was illegally retired on 7/9/1993. Thereafter, he raised a dispute in ID number 193/94. An award was passed by the Labour Court directing reinstatement. 14/4/2000.
Award dated
Award dated by 31/12/1998.
31/12/1998. Yes.
And against writ petition was filed by the respondent.
What is the ID number?
193.
193 of 90. Yes.
Writ petition was filed by the against state award.
Yes.
And they have reinstated the petitioner on 14/4/2001.
Yes.
And is continuously working.
Yes.
And the petitioner also filed a writ petition that in not insofar as not granting back wages and continuity of service.
Yes.
And both the writ petitions were heard. And the writ petition filed by the petition was dismissed. And the respondent writ petition was partly allowed insofar as granting Labour Court absorption.
Yes.
Labour Court said under 2A2, court has no power to grant such relief.
Yes.
Then while passing the order, previously, the learned thing in there said, if the services of the employees are not required, you are at liberty to return them.
Yes.
Insofar as that observation is concerned, it appeal was filed, and this also deleted that portion.
Yes.
Now, my lord, several representations are made to the corporation, and corporation also issued circular for that, for lordship will find page 12 of the material paper,
Yes.
dated 4/7/2009.
Yes, sir. Read.
The government through GOMS of 145 dated 1/7/2009 and reference 4 cited as according to permission to regulate service of 1,583 leftover employees duly adjusting the shortfall of the number of casual employees permitted for regularization by GOMS number 286 dated 5/10/2007. Reference was cited. Number of casual employees actually regularized. In pursuit of the order, the government and reference was cited. The
competent authority has accorded permission to regularize the remaining casual employees subject to the following instructions. All casual employees, drivers, conductors, artisan and traffic, recruited up to 2001 and on roads as on 1/7/2009 will be regularized with effect from 1/7/2009. The casual employees, this is class 2.
Yes, sir.
Casual employees were removed and reinstated into service and petition ID appeal shall also be regularized provided they are put into 140 working days.
Yes.
And the petitioner perhaps is continuously working 2000. Even as of today he is working.
What did they say in their counter?
Counter perhaps they say this other court has said vacancies are not there, written there. They are not direct, they are not recruited by the regular selection committee. But that is not the case for the court.
Yes, you know.
Alright, you are asked to kind permit me to the counter filed by them. Page 62, madam. There are 13 of the judgment.
Page 62.
62 of the counter filed by them.
Counter in that earlier petition.
No.
Present 52 page. Read para 13, please read.
On the other hand, the London Council appealing for the respondent workman has placed reliance on the division.
No, you are reading.
62. Page 62.
It's an order in earlier petition.
Yes, not, sorry.
Yes, you said that counter. We are referring to counter. Yes.
Counter them.
Yes, yes.
On the other hand, the London Council appealing for the respondent workman has placed reliance on a division bench judgment of the court in the service 478 of 2000 and batch dated 22nd July 2003, wherein the division bench of this court in identical circumstances upheld the findings recorded with the tribunal that terminated the workman therein of nothing but a written bed and rejected the conditions of the marriage bed that there was a contract and the workmen were working under contractor or cleaning of the buses. The judgment clearly support the case of the respondent. But in this case also their plea is were engaged by some contractor.
Yes.
But in fact, there is no such contract. Contractor whose services were terminated, he has also filed in the industrial dispute.
No, this is also Anwar's case, same petitioner's case. This petition, page 54, filed by the corporation.
Yes, sir.
There,
The petitioner.
petitioner, same petition.
Yes, it is. And the employees perhaps who are referred in the judgment 478 of 2000, they are all regularized. They are also similarly like petitioners, they were engaged without reference to the recruitment rules or regulations.
What is 478? 478 of 2000.
Recovery order manner
Yes. So the 929 or 478?
478. And the Saran court categorically upheld the finding of the labor court that these workers were directly engaged with the corporation, not with the contractor. And having engaged by reinstated him in 2000, denying him the regularization and paying them meager salary benefit.
Have you filed the 478 judgment? They have filed 929 and 1047.
Against the orders passed in 26406 of 1999. Petitioner really preferred 929. That lot, the other similar matters were 1047 of writ appeal, 1047 of 2009. And the same observation was made in writ appeal 920.
Yes, sir.
So my humble submission, my lord, it is a case where indulgence of the lots is called for regularization services.
Okay.
Having put in service from 2000.
Similar, sorry, netlo check చేయండి. It seems similar cases were disposed of by this court. There is a note put up by registry. We'll give them. And I will give you. Yes. This court has given an order to put up above restrictions along with 7489 and 13742 of 15, which was already disposed of on 28/11/2018. Note down the 7489 and 1389 of which year? 15. Same year, 50. And 13742 of 2015. It may not be relevant to the present case. It may not be connected to present case. Because there is no selection. Petitioner was never selected and appointed. This matter also. This may not be connected to this. The petition disposed directly the petitioner to submit a presentation regarding regularization.
But my lord, the same circular, my lord, which my engineer is relying upon, that 47/2009, page number 12 and 13 of material paper. The same was referred in the petition.
Yes, yes.
489.
Where it is referred?
The Lordship Justice Admin shall be order, my lord.
Yes.
The order starts that this petition is by seeking magnanimous declaring the action of the corporation not recognizing the service of the petition. Pursuant of the orders issued by the respondent 4/7/2009. As illegal arbitrament sought for a consequential direction to regularize. You see the prayer in this petition also, my lord.
Yes.
Of this 4/7.
Regularization is concerned, whether there is period after completion of 40
Please go through it.
40 days.
Yes. Similar cases were disposed of by this court. We'll pass same order. Yeah.
20 years from 2000 they are working with us. This order, several orders for part. They will not consider without representation of pay.
What did they say in their counter? Yes, Srinivas?
They did not raise anything, Milord, except legal attention alleging that labor, the Honor Court said they are not recruited through proper channel, therefore they are not eligible.
That plea is not available to you at this stage. Read para 12. As the petitioner was never recruited through Departmental Selection Committee pursuant to any notification, it is submitted that for want of more details, if employees referred, the respondent corporation is unable to confirm or deny whether the service of similar placed persons named, namely Sattaya, Jahangir, Krishna, Satyanarayana belonging to Tandu Depot were regularized. The respondent corporation is unable to confirm or deny. This is your content, counter content.
Yes, sir. most of these similar cases,
Yes.
Yes, sought in the liquidation is about petitioner is seeking regularization in pursuance. May kindly see page number 12 or 47.
Then what happened to that cases? That is disposed on. Those two cases were disposed on in the year 2018, it seems. 2018.
Yes.
28/11/2018 and 30/11/2018. Get instructions, will post on day after tomorrow. Let them get instructions. 15th.
yes,
15th. Yes. Give those copies.
yes,
One copy is enough. Keep with one copy with you for orders. You'll see.
Item 29. Give it Shivaji. Here this.
My lord, reply has to be filed in this, my lord. Kindly 10 days time may be granted.
Yes, what is the matter about?
I'm handicapped with the bundle, my lord.
Please wait. Count is here. Respond, count is here. Yes, ma'am.
We have filed challenging actually not selecting the petitioner as a junior planning attendant in terms of notification dated 1999 year lordship. But as per the records available, petitioner never applied for this.
You have filed your counter on 4/9/2023.
Yes,
1 month back.
Yes,
It's 2 months back. Yes, that request to the respond petitioner to file reply after it. Yes, madam, when you want?
10 days time may be granted.
Post on 21.
Obliged, my lord.
Item 30. Ravinder Alkuchi. Here this. You filed a counter in this month for his lordship.
Counter is also regarding selection JP.
Selection 99. In fact, petitioner had already filed a petition in the year 2002. The order copy is not available and produced at your lordship, but same issue he has filed and it was dismissed saying that he was not part of the batch. If your lordship may recollect, the issue is with regard to the 1999 notification, where it was subjected to various litigation.
Request my lordship, ma'am. Okay, my lordship. Seniors may end up in another court, my lordship.
Have you stated in your counter?
Yes, yes. Para 8 of my counter stated that I reduced the topic. Further, also the fact that the petitioner is offensive, is relying on an order of a court, which was passed in 2011, and he's seeking for a same relief. But he has approached this court in 2015. Notification was of 1999 in Georgia. I've taken two grounds. One, that is this, there is res judicata because the petitioner has already approved the court. Second, on the ground of delay. And being a fence sitter, he cannot claim for a relief on the same term.
Yes, what is the writ number? Earlier writ number?
It's a 2002, your lordship, 2817 of 2002. I produced that order copy also, your lordship. Yes,
Also.
I have a passable in.
Tomorrow, my lordship.
Yes, tomorrow.
Tuesday, your lordship.
Right? Yes, Tuesday. A request of the petitioner. Post on Tuesday for orders.
Yes. Item 31. AK Jebra Khashraw. Additional Recruitment. Answer your lordship.
Yes.
The order is only to consider the representation, your lordship. Already.
Please wait. Please wait. Please. What is the matter?
is a matter that Ella were brought on record.
Yes.
He said that he died.
Please died, your lordship.
Whereas they are taking inconsistent stand. That's why cannot be also directed to impede fifth respondent to pass the order. I will impede. But your lordship will find that the order which was passed by fifth respondent
What is the order in red?
It's not more directly to pension is here.
Order value.
For part of the other employees.
Only to consider the representation of your motion, that is the order transferred.
The civil petition is still pending. IA1 of 2019. IA1 of 19.
Yes, sir.
That is your implement petition
It's petition.
is not yet ordered. IA1 of 19 is not
Yes.
yet not ordered.
Thank you, madam.
Where is the order?
Yes, you will not be pending.
Page number 9.
Yes.
WP number 39343. Is it so?
Yes, okay,
Please read.
second pass.
Please read from the regarding regulation.
Yes, yes.
Please read second paragraph.
We have the facts circumstances stated that the application to the petitioner dated 2016 is pending. There shall be direction to the respondent authorities to dispose of the same in accordance with law and take action accordingly within a period of 8 weeks from the date of the receipt of the copy of this.
Yes, what decision has been taken?
And according to the counter, your lordship, I have filed counter, your lordship.
Yes.
According to our counter, speaking orders was passed on 3/8/2018, page number 28 here.
83, not 38.
8.
Page 28. Yes.
29 here.
29. No, 28. 1 second.
28 and 29, sir.
Yes. What is the name of Vishnu Venkat Narayana?
29 page, paragraph 2 here. And we.
1 second, 1 second, 1 second, please. Yes, read.
Therefore, N. Venkat Narayana, claiming the regularization over the senior as per CC number from does not arise. There are similar cases pending in the Honorable High Court, adjudication in Hyderabad for the state of Telangana and state of Andhra Pradesh below. WP number filed by B. Raja, type of late V. Lakshmi Narayana. WP number filed by B. Ramlama, type of B. Ramlu. WP number 24910 Euphoria. And in these cases,
Your lordship, kindly read.
in respect of serial number 3, liquidation, Surya, he has retired, regularized, and his salary enter amount has been paid.
Yes.
Because I appear in that case.
Yes.
In all the cases. And with regard to Ramlama, right, liquidation was filed. She was seeking compassionate appointment to her son. And accordingly, order for court, the son was given compassionate appointment.
Yes.
And she is being paid pension.
Yes.
Now, as far as the petitioner is concerned, he is legally wedded wife, he is not in a position to get any pension or pensionary benefit. Now, the respondent admits, chief engineer also, that the petitioner was senior to other employees whom he has reported. They permit to place you on record for that before your lordship. The order passed by the chief engineer. Page 56, paragraph.
Yes.
Page 56, last paragraph.
Read.
Page 56.
Yes, sir.
In this correction, I submit as per the superintendent engineer report, Sri Venkat Narayana NMR, winch operator serial number 52 of senior chief of winch operator, junior A. Prasad NMR winch operator, serial number 54 of senior lead of winch operator of erstwhile AP State Construction Corporation Limited. Among services were regularized by the government and memo dated 17/4/2014 in terms of GOMS 140, dated 63/84, GOMS 56, and GOMS 88, excluding boy service and their labor code for legal purpose. As per executing the service particulars of Venkat Narayana, His age as the initial engagement and 60 CMR which operator. Yes, right. It is 19 years and 8 months. Hence, the service of Venkatnara NMR, which operator of Astral AP Construction Corporation are to be regularized on par with junior CA Prakash NMR, which operator. And serial number 54 of seniority and completion of 5 years of NMR service in terms of GO 143, dated 6384, also. High Court dated form.
So Prasad services were regularized
Regularized.
or to be regularized on par with junior Prasad. Yes.
Page 29, first paragraph, your lord.
Yes.
The N. Venkatnarayana, son of Narahari, was repatriated to the NSLV co Thirupalli Kamam as per GO 12.0. As per the presidential order that the local candidate with reference to the study center.
No, this is also issued by ENC. This letter page 50.
The individual shall
14/7/2000.
with the condition that the individual shall forego lien and seniority from his parent circle and will take last rank in the same cadre in the reposted circle.
Yes, yes, by taking into consideration that issue, on 14/7/2016, a letter was addressed by Engineering Chief to the Principal Secretary. Please read the last pair of that letter. Page 55. 55. Page 55 dated 14/7/2016.
Yes.
Next page, page 56, last para. In this connection,
Services are regularized with the government memo, so put it in terms of 143, excluding voice service of the labor code. His age as an initial engagement also. To be regularized on par with the junior Sri Prasad, which
yes.
completion of IS and MR service in terms of.
Also above that para, the superintendent engineer has requested to obtain necessary directions of government for regularization of services. In consequence to this letter, Sri Venkatnara, son of so on par with junior Prasad, son of so and so, to avoid legal further legal complication. Get instructions.
Yes.
Again, you cannot say, you cannot reject because this is the basis. You have to take action, further action on this letter. Yes, prior to the rejection order.
After that,
Now government has to take a decision in this case because ENC also already wrote a letter to the principal secretary.
Sequent to that, 8/3/2018 is the speaking order which was passed. I'll verify.
Contrary to that letter, you cannot pass that.
I'll verify.
You yourself recommended for regularization. How can you reject that? A request to the respondent to get instruction from the.
Please write your notes in the year 2020 itself. Death certificate.
The LR petition is already under. LR application is already under. Yes.
I'll verify.
Yes, you will get pension.
Yes, yes.
Only a time rule.
A request to the respondent, Additional Advocate General, to get instruction from respondent number 1. Regarding with regard to the letter dated page 56. With regard to the letter number ENC/IW/PNM/NTPA/W2/1056/2015 dated 14/7/2016, wherein the first response, wherein which respondent has recommended here? Second response, wherein the second response has recommended the first response for regulation, wherein the second response has recommended the case of the petitioner to the first response. Where in the 1 second? The first responder requested to issue, requested the government, that is first responder for issue necessary inspection. He himself recommended, he cannot take, yes, implead, I have 1 of 2019, impleading.
But that was recorded in the year 2000.
What the order?
Yes, you are impleading whom? You are impleading whom?
Respondent, my lord.
Who is fifth respondent?
Your
Yes, 1 second. Proposed respond, fifth respond, Nagendra Rao, engineering chief. Yes, implead is ordered. I have 1 of 19. Still he is in the same position, 2019 IA. Please find out whether he is still in service or not.
He Nagendra Rao, engineering chief. But at the time, my lord, Kisan person. He is the person he implemented. That is the reason, my lord, I have. And the-
No, please find out whether he is in service still or not.
I have to make. my-
Yes, madam, you have to give for the case. 21 left.
Item 32, Emporia, Dakar Dinesh.
Yes, madam. There is an interim order in the
Against litigation also. But there is a appeal remedy is there, but without appeal, they file.
is still in service. Still in service. What is that memo 2011 2010?
So the amount of petitioner.
How much amount?
20 lakhs.
20 lakh. None of for the petitioner. Post next week. We'll see next week.
20 lakhs.
Yes, 20 levels.
Item 33, D. Ravishankar Rao, GP for labor. Gandasala Vijay Bhaskar. We are appealing for respondent numbers. What is the issue? 10 of 2009. 1 second. You are appearing for the workmen. Remote is compliant. This court has directed to pay the salary and also directed to deposit the amount 25% of amount and also permitted to withdraw the action.
75% of the backways are awarded, but I'm not. 25% is ordered to deposit and permitted to withdraw. But request of the none appealable the prisoner. None appears for the prisoner post on. You want to take steps? Yes. 21/11. 2023. It's post for dismissal.
Recently known about the respondent is paying oil production.
Yes. None appears record చేయండి.
Item 34, B. Umadevi.
Millard, this matter may be taken up next week, Millard, because the system shows counter is filed, but I am not having a copy of the same. I asked the respondent corporation to furnish a copy. But to enable me to make my submissions may be taken up next week, Millard.
May I please your lordship, I am representing the Malika.
Yes.
The petitioner already retired from service 2002.
Yes.
The respondent corporation issued charge memo dated on 2010. After lapse of 8 years, they have issued charge memo and final orders was issued. I have filed appeal and same was rejected in 2011. There is no relationship between the master and the servant after my retirement.
Where is the order? Impugned order?
Impugned order is page number 12 to 13.
Where is the original order?
14 to 15.
Yes. Charge memo? When was he retired from service?
2002.
Date. Give the date.
36 2002.
30 June 2002. Yes.
30th June 2002.
Yes, yes. What is the date of charge memo?
Earlier charge memo issued on 19/3/94.
19/3/1994. Yes.
With a imposition punishment imposition of stoppage of 2 increments with cumulative effect.
Date of order?
I have filed WP date of order 23/4/2007. It is my material page number 23 to 24.
Not this. What is the date of punishment order?
As per expedition, it is 19th March 1994, Millard. That is a charge memo.
Charge memo.
Yes. Date of punishment.
Date of punishment is 13/10/2010.
In pursuant to the first charge memo, 93/94 charge memo.
Yes. That charge memo was set aside by this honorable court, your lordship.
Sir, give the facts of the case. You said earlier charge memo dated 19/3/1994 was issued. It was concluded as by the imposing punishment of stoppage of 2 increments. What is the date of order? Date of punishment order.
2008, 2/11/2008. Page number 25.
Come to page 23.
Page number 23 is earlier I have filed the questioning the charge memo. Disciplinary court has passed orders.
Yes, saying what? That side or?
Final order. The restriction was allowed.
As much as the petitioner herein has not been given an opportunity being heard before the disciplinary authority. Yes, thereafter what happened?
After that, before that I have retired from service.
Yes.
After that, they have issued a notice dated to 21/11/2008, material paper at page number 25.
Yes.
Due to the retirement, I have not submitted my explanation. After that, they have issued proceedings dated 13/10/2010.
Page number?
Page number 14. I have submitted my explanation at page number 16.
One second. Page 14. Page 14 is the
notice, final order issued by the respondents.
Where is the inquiry report? One second. Final order is dated 13/10/2010.
Yes, your lordship.
Here is your explanation. It is 18/1. 8/1/2011.
Page number 18.
Page 16.
16 and 18.
Yes.
After that, they have issued the final order. After submitting my appeal, 15/4/2011, page number 12 is the issued order.
Yes. Where is the original order? 13/10 is the original order.
Yes.
What is wrong in it?
After my retirement, your lordship, they have issued the said
Court
proceedings.
has given. Now come to page 54. Page 23. Order in WP number 306661 of 97. Read page 24, last para.
Opportunity given to the opportunity the delinquent employee.
Total para, please read.
I submit that even on merits, the punishment is unwarranted.
Please read. Counsel, please read last para of the judgment.
Inasmuch as the petitioner herein has not been given an opportunity of being heard before the disciplinary authority, has chosen to differ with the findings of the inquiry officer, the impugned order of punishment as confirmed in appeal is liable to be quashed.
Yes. Next, further.
Needless to state that this order shall not be preclude the disciplinary authority from giving such an opportunity to the petitioner and thereafter take action against him in accordance with law.
Yes, what is wrong in it? As per this court order, they have proceeded further and issued final orders on 13. Yes.
Main charge memo issued stoppage of 2 increments. And at this stage, they are recovering the arrears of the 2 increments.
Is there any stay?
No stay, Your Lordship.
This order is passed after your retirement.
Yes,
Order
yes.
WP number 30661, 1997, dated 23/4/2007.
Yes, yes.
According to you, petitioner was retired in the year 2002 itself.
Yes.
Nothing is wrong in it. Yes, heard.
There is no procedure, Your Lordship, there is no procedure and a discipline and appeal regulation for recovery, and the same is outside purview of my discipline and appeal regulation. As by retirement, the relationship of master and servant has come to an end. That is my submission. Your Lordship kindly pass necessary orders.
What did they say in the counter? Yes, heard both sides. Yes, Surunarayan.
Milord, I'm not having a copy of the counter, Milord. That's why I'm seeking a adjournment. Furthermore, it is not true to say that after retirement the inquiry proceedings were initiated. While the petitioner was in service, the charge memo was given and punishment of Milord.
Can we dispose now? Are you ready?
No, Milord, because I'm not having counter copy, Milord. I asked the officers to furnish a copy. Your Lordship may post it and Tuesday I will make my submission.
For orders. Yes.
Much obliged.
Obliged, deeply obliged.
Item 35, Pillara Valanti, Andiram Krishna, K. Bhaskar Reddy.
2011 matter. Maybe. What is the issue? Who is the appellant petitioner?
We inform the petitioner counsel we are taking time.
2011 matter, how can you expect time? You are appealing for which respondent?
4 to 6 were completed. I appear for the 5th respondent.
You are appearing for fifth respondent. Your
4th respondent recently 11th July we filed Wakalat after.
who is appearing for R6? R6 notice student. So, what is the issue here?
This is regard to the payment of monthly monetary company.
Wife has filed this report. Second one.
Week.
Yes, none of us are petitioner post next week. You are not filed counter. Both of you. None of us at request of the none of us for the petitioner. At request of the respondent for filing of counter. Post on when you want? 14th. 21st.
Item 36, K.R. Prabhakar, LVS Nagar.
Yes, Kishore.
Agra's is not standing council now.
Oh,
We came to government.
LOS not. It is government, no? Who is applying for response? Gopal Reddy, residential institution.
Let's move on. This is school structure. Let's move on.
Yes. None appear for the petitioner.
The case status is matter pertaining to transfer, right?
Yes. None appears for the petitioner. Post on 15/11 for dismissal and register directed to print the name of Gopal Reddy in place of Nagaraj. LOS.
Item 37, G. Vasantradu, Srinivas.
What happened in this matter, the petitioner retired from the service and challenging the denial of the promotion. The petition was filed and subsequently their interim directions was passed to consider the representation. Where the speaking orders were passed that taking that the criminal case is pending against the petitioner and it will be reviewed after disposal of the criminal case.
Yes.
The criminal case ended in acquittal and thereafter he filed an application before the authorities saying that the criminal case is dismissed and during the pendency of these proceedings will not be retired. Therefore, he asked for a notional promotion and for adding the increments whatever that is due. And that application was considered and dismissed on the ground Millard. The acquittal order is only by giving the benefit out of.
Yes.
And therefore, that is not applicable. The order that was passed before this filed Millard along with my petition.
What is the punishment here? What is the punishment?
Punishment it is acquittal Millard. In fact,
Not in criminal case, in disciplinary court, department of proceedings. Any punishment was imposed?
Only increment Millard without cumulative effect. And they say that the criminal case is pending, therefore your promotion will be considered reviewed only after the disposal of.
Now you are seeking only notional promotion.
Yes, we are seeking for notional promotion Millard and the order that was passed in the criminal case is ended in acquittal Millard because 116 of the.
What is the issue? What is the issue?
Millard that he was deputed as managing director of SCORE Millard at Recruitment, where they had implemented the pay scales of the AP transfer employees Millard. And the joint director has given a complaint that he has not obtained prior permission for the implementation of the previous case.
Yes.
The government has ratified that whatever the action taken that it is on par with the government AP transfer employees. Therefore, the requisition filed by the employees were not closed. The petitioner has also approached the Supreme Court that the criminal case filed under section 4. Yes.
No. Again, for what action that the criminal case was registered?
That I have not taken the prior permission from the
For which charge memo was issued
and
also criminal case was registered. What happened to the disciplinary proceedings ended
in
one increment
without
cumulative.
And also the criminal case ended in acquittal.
Yes.
And
Yes,
they have not considered, only are saying that the criminal case was
It is ended after completion of the punishment period.
With the cumulative effect, it was given.
Yes, maybe for 2 years. Then he is entered. What is the date of retirement?
27/2013.
21/7/2013. What is the date of punishment? Punishment in this department.
5/9/2011.
What is the date?
5/11/2011. 5/9/2011.
5/9/2011.
Except the employee, Milad, the petitioner, no action has been taken against any of the employees of this board. Clearly case of victimization. Even otherwise also, Milad.
So without cumulative effect, one increment without cumulative effect.
For the main allegation, my lord, is that, my lord, without the permission authority, because that's for actually a paid employee, because they submitted request.
Already he has suffered with punishment imposed by this department. From which date you are entitled for notional promotion, as according to you? How many candidates? Only one applicant here. One repeat.
Yes, one request, 2 increments. If it is given.
Punishment was imposed on 5/9/2011 without cumulative effect.
Yes, Milad. And subsequently his promotion was denied.
What is the date of denial according to you? What is the material on record?
15/11/2011, Milad. This is the order that passed.
15/11/2011, you are not entitled because you are under currency of punishment.
Yes, Milad.
Yeah.
So subsequently, Milad, he is what he says to Milad that 2 increments are.
What is the objection?
Punishment imposed, my lord, because not only one charge, there were 3 or 4 instances.
Whatever it may be, that was ended by imposing one increment with cumulative effect, without cumulative effect. Only one punishment according to you. When according to, as per your proceedings also, 5/9/2011. Please read that page 18, impute proceedings.
What the consider should picking orders of the stating that candidate for promotion the procedure will be considered and reviewed after completion of the punishment period according to this.
Where are you reading, sir? Yes, Thompson. Read. Read.
Page 18 para 14.
1 second. Let him read. Para 13 onwards.
No, I filed it.
Not that. This is the impugned order at page number 16. You are challenging this page, not 16. Page 15, dated 5/9/2011.
Subsequently, the orders were passed. Oh, I challenge this, Milad. Subsequently.
Your prayer is this.
Yes, Milad. That is prayer and subsequently I find it should be saying XL 1/23. IA 1/23.
1/23 on the amendment. That is not on record. 1/23 permission petition. 2/23 is amendment petition.
Where I have stated all these facts, Milad, that in persons of the interim directions of the Honorable Court, Milad, they had passed the order. I find it page 1 and 3 is the orders that were passed.
Speaking order has been passed.
Yes, Milad. Speaking order passed on 15/11/2011. Pursuant to the directions of the Honorable Court, where they said that they will be considered after reviewing outcome of the criminal case. Now,
the cost side.
No, 2 applications was filed. 1/23 is.
1/23 is permission petition.
Permission petition.
2/23 is amendment petition.
Petition by filing the additional.
Then we will close the writ petition.
Notice of the Honorable Court.
Yes, we will close the writ petition, giving liberty to challenge that speaking order.
No, Lakshmi, kindly consider instead of doing Milad, let them say that whether their action in disposing of Milad by considering that criminal case ended in acquittal. They said that it was given a benefit out of. On that ground, you will have to make the material paper. No, you will have to make Milad because all the time he has been suffering Milad, he has denied the promotional opportunity. And subsequently, after
No, even this punishment of one increment was imposed on 5/9/2011.
Yes,
He was retired on 21/7/2013. In between, whether you are entitled in between of this period, Whether the petitioner is entitled or not, that is the issue here.
That is the issue, my lord. In fact, in pursuit of the directions of the Armed Court, they passed the order, my lord, by reviewing this promotion and also the further chances, my lord, after disposal of the criminal case. And the criminal case has ended, my lord. I approached the authority saying that
Request to the petitioner post on 15/11.
let them file their counter, my lord, justifying their action, my lord. I will.
Already they filed their counter. They have filed their counter. Amendment కాలేదు count
Amendment lo they had, I had given an additional affidavit, all bringing to the notice of the Armed Court, all the facts.
If order that IA, then you will file counter if you want. Otherwise, we'll close the writ petition with the liberty to challenge because
This is a
the
simple
2011 matter, how long is
No, it is a simple fact. Let them say, my lord, that they are justified in doing this.
My lord, they challenge the order, my lord.
what is the data speaking order?
It should be part of the record.
17/7, my lord, amendment should come to the record, my lord, 17/7/2021. I filed it along with this little.
You just now you are referred in your counter. Which para?
Counter.
Just now you read.
Last para of the count. 18, page 18 of the counter.
Yes.
Submit the order.
One second.
Removed in accordance with the rules.
1 second. Page 18 is missing. Madam, the page 18 is the last page. Missing. Only 16 on. Yes, read. It is missing 2 papers.
The order issued by memo dated for accordance with the rules and regulations. As the interim director, the Honorable Court Services, the response has answered the case of case issued speaking orders for petitioner stating that
Good.
candidate for promotion of
16, 17. 17 and 18 is equal. 17 and 18.
In order they want to challenge after my lord filing of inspection, my lord, they will have to the file a petition to amend the prayer itself. That is not there in this. After interim direction, my lord, we have issued speaking order.
Yes, yes. Direction was given in the year 2011. You have passed order in the year 2017. Now, after 6 years, he wants to amend the. What is this?
2011, we have not engaged model, page 18.
Read, relevant para.
Last 380 last para.
Yes, sir.
As per interim direction of the Honorable Court, the response have considered the case of the petitioner and issued speaking orders to the petitioner.
What is the date of speaking order?
Speaking order stating that the candidate for promotion to post will be considered and reviewed after completion of service.
What is the date of speaking order? You are not filed along with even your counter.
Equal to this interim
My lord,
direction.
the speaking order, my lord, memo that is dated 5/9/2011.
That can't be because interim order is on 8/11, 2011.
I'll
You are also not clear.
I need along with the papers.
Yes, at request of the petitioner, post on 15/11 and list is directed to put up IA number 1 of 23 and 2 of 23. Post on 15/11. We would have filed a speaking order. Date of speaking order is not there.
11/2011.
You have got a copy. Yes, yes. We'll see on that. 15/11.
Item 38, G.V. Shivaji, GIP for agriculture. Gamla Ashok.
My lord, the issue is relating to regularization of the petitioner service, my lord. Counter has not been filed. On last occasion, respondent counsel has taken time to file counter, my lord.
Yes, sir.
My lord, this is pertaining to contract employees, my lord. They were appointed for 12 months, my lord. At the time of appointment, my lord, they are given a bond, my lord, seeking that they will not go approach any honorable court regarding regulation of their services or for continuous services, my lord. Meanwhile, my lord, the government sanctioned some post, my lord, where the board had insisted for some qualification. As per the qualification on merit, they were selected, my lord. Some of them, these employees had appeared in the interview, but got response.
For that reason, they are not selected. Other employees, they did not approach madam for their own reasons. Now the board had taken decision. The managing director had given them reply letter stating that due to merit, on merit these people were selected, on qualification they were selected.
Read the prayer in repetition.
Yes, madam.
What is the prayer in repetition?
They are asking for regularization.
Then
Well, how can we, my lord, when they are appointed for contract basis for 12 months period, now these people, government had sanctioned post with some qualifications.
can we record your statement in the open?
My lord, I filed my counter, my lord.
When did you file?
My lord, we are filing, my lord.
When will you file? 2011 matter.
It is ready, my lord, only we
There is a direction in their favor to maintain status quo and further direction.
my lord, we are not
Further directed to consider the representation dated 17/11 to
20th of this month, my lord, but it was advanced, my lord. Why I don't know. But already counter is prepared, my lord. I require only signatures. My lord, give some time, my lord, I file the counter, my lord.
ఎప్పుడు ఉందండి అది
20th అని చెప్పు.
మీరు తెలుసుకోకపోతే ఎట్లా ఎవరు చెప్పారు 20th
అలాగే చెప్పాను నెక్స్ట్ మంత్ అన్నాను
డిసెంబర్
My lord, the counter is ready, my lord, only acquire
request of the respondent to file counter post on 14/11.
2 weeks, my lord.
No, ready. File in the registry today or tomorrow.
No, my lord.
15/11. Yes. As a last chance, post on 15/11. You are saying that the count is ready. తీసుకోండి ఎంతసేపు ఫైల్ చేస్తారు yes
Milord, item number 44, I informed the other side, matter may be taken up next week, Milord. 44, Milord.
I will not see this call list mentions are at only at 10:30 only. No, my
Sorry, I'm sorry.
Instructions are not ready. Therefore, 56 and 59 may be adjourned. Only for that.
See,
Last motion. Item one, Naresh Reddy Chinmaya, Kundara Ajay Kumar.
Have you informed the other states?
Yes, in the guidance, positive matters. Question for finally,
In the absence of other side, you have to postpone. Post on 15/11. Intermodal granted by this court earlier, but then 6/10/2023. Shall stand extended till
Considered matter. Item four, P. Sridhar Rao, Madam Srinivas.
This matter, we are challenging the orders of the restaurant. Just say how. Very important. No certain conditions.
page number. Page number 29. It's the impugned order. Yes, 2005 impugned order. 2005 order, you are charging 2011. Yes.
So this order is taking place only on the, based on the account, based on the criminal case which was registered before the court.
Read.
Have gone through the review.
Yes. Yes, read.
Have gone through the review petition and the connected material. I find that based on the material on the charges are rightly held in as seen from the case. It is clearly understood that this is the case of a fatal accident. Further, it is seen that the appellant has appointed as driver during the year 1980, that is, had put up nearly 24 years of services in the corporation. During this tenure plan services, this is first incident wherein the appellant was removed from the services, keeping the long years of the services into consideration to the punishment imposed by the department. Is appropriate and the proceedings are fit and proper. It is a judge decided to view the case leniently and reinstate Sri M.B. Swan, that is also rather of Swanson depot subject to the following conditions.
Yes.
These were the conditions followed. The appellant is reinstated to services driver and post clearly in the report. The period of removal shall be treated as not on duty allowance, and the security depositor is forfeited and shall collect SD once again afresh. A deferment of annual increment for a period of 2 years with cumulative consideration may be directed to medical officer, that is for medical examination, and he shall be appointed as driver after being declaring as fit and as fit for driver's job by medical officers. The appellant is directed to report to depot within 1 week from the date of the receipt of the proceedings. Failing with the order stands cancelled, my lordships. So these are the orders which has been passed by the rescue number 2, my lords. All these things happened, my lords. He was being suspended from the office, my lordships. They have filed the charge sheet, they are suspended him, the inquiry has taken place. All the things were very biased, my lords. We are given his explanations, though the explanations were not considered, my lordships.
Where are those explanations? Where are those findings?
offering this one options.
Yes.
They have not participated.
No, on what ground you have filed this petition?
Only Margaret, acquittal grounds for justice.
Read,
He has been,
read para 5.
hello, hello, sir.
Your affidavit.
I also submit that the criminal case was also registered in consequent to the accident took place on 26/11/2003 on the part of the Honorable Fourth Additional Judicial First Class Magistrate for in criminal case number 31 of 2014, the said case, the Honorable Court by its judgment dated 17/3/2010 after trial on merit, held I was not found guilty for the offence punishment under section 304A, 337 and 338, and acquitted under section 255 sub 1 of CRPC members. On receipt of the judgment copy, I made a presentation dated 29/10/2010 to the depot manager, Yatri Gupta, requesting him to grant the monetary benefits with effect from 5/2004 to 28/4/2005. That is for the suspension period and also for the period I was kept out of the service. It is submitted that the consequent to the retirement of the service on medical grounds with effect from 2/11/2006, the respondent corporation had paid an amount of 4 lakhs towards PF SRB. I submit that I have not committed any misconduct as alleged by the respondent corporation, and the Honorable Fourth Additional Judicial First Class Magistrate Warangal appreciated and acquitted me. The second respondent here have also considered my unblemished record of 24 years of services and granted the relief, but partially. If the respondent corporation has considered the explanation submitted by me in a proper perspective, the depot manager, Narkatpalli, ought not to have passed the removal orders dated 11/6/2004. I am advised to submit the orders 28/4/2005 passed by the second respondent is unjustified insofar as treated the removal order is not unguilty. Further, imposed deferment of annual increment for a period of 2 years. I also submit consequent to retirement, retiring me on medical grounds with effect from 2/11/2006. The respondent corporation has not paid the monetary benefits for the leftover service, wherein I could have superannuated from services in the year 2009. Therefore, I am entitled for the said monetary benefits as per the circular issued by corporation for time to time.
Benefits are paid.
Yes, we have paid. Also, we have paid. Last 3 lakhs on
Have you received benefits?
No, my lordship, what they paid, that is not the benefits. He is seeking for the entire benefits, my lordship. From the suspension period, he is seeking for the benefits.
What is the suspension period?
Suspension period.
Yes, third both sides will go for it.
5/2004.
So it's just waiting on criminal acquittal that getting reached it. 2005 removal.
Yes, madam, we'll pass orders.
The retired of 5,000, not max, on 6.
We have seen that. Yes. Reserve.
Item 7. Take Krishna Rao. Dave Morris.
Mela.
Sure. 7.
7.
Business for non-prosecution.
Much obliged.
Item 10. M. Vishwanath.
Business for non-prosecution.
Item 11, Gopandana Chellavi.
Yes.
Yes, ma'am.
Yes.
Yes. I will pass. Oh, yes. What is the user number? Strong label. Yes. In the matter taken up already. The counts of petition submitted. What is your name? Narsimlu. Narsimlu. Strange. Mr.
Item 16, A Jagan, Pastor Ready.
This cover pattern and the honorable justice superintendent of it's lost fifth pattern. For the
Yes.
fifth pattern. Last
By following this order, in petition number 8090/2010, 12/4/21, application. Section 5. 6/3/2011.
5/3/11, 6/3/11, 20/3/11.
Without prior permission or sanction from the competent authority. Right. Option 50 is from 5/3/2011.
Okay.
Item 19, please take the top.
Location, there was like the docket orders to find the inland lot.
Madam, we can't remember what was this thing we seen last year.
And the granted a time. So we will be filing the inland the docket order to find the lots.
Proceed. Yes, madam, proceed with the case. Inaction of the respondents hearing not relating to service benefits as per the orders. So dispute is the amounts which are paid.
What the amount they have paid, that is.
Initially, they filed petition for
Where is that recorder?
page 20, 9. I will give the idea of page 20.
Yes, 1 second.
First is the prayer. Again, the petition. Petition on the process. ID was challenged.
Challenge, yes. What happened to this petition?
The inspection order was 26.
Yes.
Petition is granted the relief of continuity of service.
So only for the purpose of granting retirement benefit by calendar.
So, no wages were granted. Now, again, in this petition, they are taking wages.
My lordship.
Now, in ID or petition, the relief was not granted. Now, again, filing another petition, filing a claim for wages.
My lordship, package page number 7, my lordships.
Yes, read.
My lordships. Page.
Read.
Also submitted that as per the judgment dated 12/12/2012 in W numbers also, the continuity of services for the period of from 23/6/1997 and the renewal from services that is 25/11/1997 to actual reinstatement as Shramik, that is 26/2009 has not been notionally fixed in the pay scale.
Has to be notionally fixed.
Yes, my lordships. And the revision took place from time to time and as per the law laid down by the Honorable Court and the Honorable Court, where pay protection has been granted in a year of alternative employment provided by the employer as per Act 2005 and as retired from services on 31/3/2012, my lordships. Attended the age of superannuation and I was paid the retirement benefits of rupees only 40,000 towards PF and 16,000 towards SRBT, my lordships, on basic pay of Shramik. That was paid only for the Shramik payment for the period what he was employed, my lordships. It is submitted as per the judgment dated 12/12/2012 in WP number 23176 of 2009. I'm entitled my service benefits and monetary benefits for the entire post services for the entire past services. That is from the date of appointment on that year 1987 till the date of retirement on 28/2/2012 and also entitled for
No, that is not the issue before tribunal or writ petitions.
ID was tribunal pending.
Yes.
Page 18. Page 18.
Yes,
In
read.
the result, is found by sitting as the removal order. Given so that respondent to register the petition as well.
Afresh. No, that is modified by this court.
Granting continuity of service.
Yes.
So, duly calculated cost of increment. We have calculated cost of increment.
Yes, where is stated?
And 7 of our contract.
Read.
As per the interim of this form, the petition, the respondent corporation create the following difference of terminal benefit amounting to 2,06,423. So, the petition as per the eligibility newly awarded national increments. The difference amount was paid.
Madam, we will close the writ petition with the liberty to make a representation if any grievance, even then after receiving of this 3 lakhs, 2,56,000.
That's what they are saying. The counter is what the payment they made when he was employed as a Shramik at that time for the period when they paid the payment, my lords. They did not make the payment for the 2006-2000 when it was not on duty, my lords. When the
Direction of this court is only to take notionally. That
my lords, I work
I mean, guess why you are leaving to the police.
What not that way?
This petition is filed.
Under section, let the suggestion now, okay, please read.
When petition is challenging the action of respondents in trying to dispense with the service of the petitioners as helpless people.
Counter is right.
Counter not. And they- It's a well settled principle mirrors that contract employees cannot be replaced with another contract employee.
Is there any interim order?
There's no interim order, but whereas in the previous occasion, the respondent council has came forward and stated that among 10 petitioners, 3 of them were reinstated again. But they are trying to take instructions with regards to remaining 7 plus. If you kindly look at the docket proceedings, they sought time for instructions.
Yes, counsel, who is appearing for respondents? None appears for the response post on 14/11
Dismissal caption.
for dismissal. For others or for dismissal?
Item 40. MA Ali Masjid. Bin Narasimha. The payment of minimum wages. Usually the action of the response.
Yes, paid.
Different manner. In restrictions for that. All matter that they is a contract.
Classical Kannada song, everything he sings.
Counter is adjourned, madam. Madam, file your counter. It is not on record.
Already filed. This is number 19469 of 2016. 27/2016 form filed.
Yes, it is there. Is. Yes, madam, read your counter. Five. I humbly submit that the so-called notification dated 3/6/2009 issued by the Labour Department of Indian Government was the only draft of
notification. Calling for the objections and suggestions but not final notification. As such, the same notification has no force in the IFR. However, the answering response.
Yes, get instructions. The response are willing to pay difference of wages. Yes, get instructions. Get instructions and request to respond to none of the petitioner. Post on 5th, post on 16/11. The meanwhile response are directed to get instructions.
Item 41. Consideration in draft. P. Lakshman.
Mr. Councilman, file and which of our also here 1 of 23 filed amendment of the respondent last item.
The order చేయమంటారా లేకపోతే మీ టైమింగ్ అంటారా? You are appearing for?
Petitioner.
Just now you said that you are gain of
Yes, unless of our file.
They have come on record.
What is your name?
Naishram. File unless of our L inverse in our.
అవును ఒకళ్ళ చూడండి మేడం. Amendment of clause 18 is IA 1 of 2023. What is the matter? Please argue the case. Yes, madam.
The petitioner is seeking dispassionate appointment as the terminal general. But whereas as per our contention, the compassionate appointment cannot be given for petitioner.
Why?
Because the petitioner's brother was working as an assistant account officer in our department corporation.
Yes.
Whereas he got married and his wife also got expanded. As per the rules of the APHCP regulations, it stated like if the brother is unmarried and if he is below 18 years, he can be eligible for giving an appointment as a companion. The petitioner over here was 38 years old, my lord, at the time of the death of the petitioner. On that basis, the compassionate appointment.
The time of the death of the
petitioner's brother, my lord. The petitioner was 38 years old.
Yes.
As per the SSC certificate. But whereas the rules, revised pension rule in 1980, according to the rule 47, 48, and 49, where it defines about the family, in that it is stated that the brother below the age of 18 years can be given as a compassionate appointment.
Yes, sir. 1511 for orders. 1411, yes, 1411. Yes, sir, and the registry is directed to Tinkanini. Indrasenarati. Initial? N initial. Indrasenarati in place of Chandrayasun. Post on 1511 for orders. Get ready.
I don't want to. Yes, Mr. Ishwan. The services.
Yes.
Then petition is filed.
Counter is filed or not?
Yes, sir, it's completed.
Yes, what is the issue?
Present petition is filed. Challenging the issue of respondent number 2, including major penalty of withholding money increment with cumulative effect on 18/7/2000.
You are appealing for R2? Who is appealing for R2?
Both R1 and R2.
AP services. Yes. Yes. The GP is appearing for R2 or not? Yes.
The respondent has seen standing counsel by them.
Now these matters are handed over to our respondent. Government figure. Yes.
Look, on the order dated 18/7/2011. Let's I just like to and attention to the lordship on page 14, P1.
What is this 18/10/2012?
Before submission, clear not the file state not the issue not the national level.
You have to file the amendment petition.
There also file the
What do you want now? The
first page of this matter. The list for first page. One the combined state.
But kindly look into the 18/10/2011 procedures. I'll make submission regarding this. Petitioner was sent to Tanaku in arbitration.
File an amendment petition.
Let's kindly look into this.
Yes. Look at the cause title. AP State Seed Certification Agency. Director member of AP State Seed Certification Agency. Chairman AP SSCA.
Orders is passed by them only. Their office is at Hyderabad. Their orders are passed by them only.
You have to file an amendment petition.
Now,
File amendment petition because it's yes, it request of the petitioner.
petitioner was worked with in Hyderabad.
Sir, he is taking an objection that the two states are involved in the dispute. For that, you need to file the amendment petition. If the two states are there, when Telangana is there, you have to state that.
Even otherwise, I filed amendment petition brought Telangana State Seed Certification Agency.
You have filed already?
No, even otherwise,
Yes.
the orders are passed by AP Seed Certification Agency by them.
Yes.
Again, now they will come and they will object that we are the not parties who pass the orders. Even otherwise, if I filed amendment application, I brought Telangana case difficulty.
Go to the first page.
Taken. I understand, back then they are AP seats, then
Now it is Telangana seats.
then it's up to them. I am not a
Get instructions.
with the order.
Conductor, please get instructions. It requires the government leader. Post on 15/11. Get instructions. Let me see. 2012 matters. Get instructions. Otherwise,
I'll direct them to give the names to what
yes.
they were
Furnish all this.
amendment.
Yes, get instructions because the these and AP seats for corporation was issued that proceeding. It is binding on you. As per this reorganization.
And even
You cannot say take such free.
cooperation is also existed to us. I even recently I sent notices to them. Then Chief for Services has come in.
Get instructions.
The respondents are still in existence.
Yes. That request to the government leader. Post on 15/11. For instructions.
Item 43, Chandrasekhara, B. Umadevi.
The punishment of
Withholding
withholding including without.
Kindly just before the petition,
There's already over. Let them get instructions. Yes, please. We'll decide on that day. Yes.
Milad, item 43 may be taken up. Tuesday, Milad. Umadevi wants to appear in this matter, madam. She is held up in the third degree.
Yes, madam. Request of respondent. Post on 16/11.
Item 44, G. Shivaji.
Milad, in item 44, we are not having the bundle. I informed the other side, Milad. May be taken up next week, Milad. I informed to the Leonard Council for the petitioner, Milad.
That 2010, 11, 12, 13. No adjournments will be granted.
Not handicap with the bundle, that's why I am respecting.
It is your duty to construct the bundle. 10, 11, 12. We are making clear that 10, 11, 12, 13. Counter is 5. What is the matter about? What is the matter about, madam?
Petitioner for the post of trainee sub-engineer.
Yes. Yes. Why they are not appointing?
My lord. My lord,
Yes.
with lordship's kind permission, my lord.
Yes, madam.
The petitioner belongs to SC community, my lord. He passed diploma in mechanical engineer. While so notification was issued on 3/1/2011.
Yes.
For the post of trainee sub-engineer, my lord.
Yes.
Notification is from page 9 to 18. Page number 9, my lord.
Yes.
350 posts were.
What is your legal right?
I'm getting into that, my lord. The 350 posts were notified. Out of that, 310 posts were general recruitment and 40 posts are backlog, my lord.
Page number 27, my lord. Page number 10, my lord.
Yes.
For second table, my lord, mechanical branch. For Zone 6, 14 posts were allotted, my lord.
Yes.
And out of that, SC General, 1 post, my lord.
SC General.
1 post.
Which column we can?
Sixth, my lord. Serial number 6. GR. Second table, my lord. Mechanical branch.
1 post was notified. Yes.
Yes, my lord. Now, page number 26, my lord, kindly.
Yes.
Wherein orders were issued.
Yes.
In Zone 6, out of 14 posts, only 7 posts were filled up, my lord.
Excluding that post.
Out of 14 posts, only 7 posts were filled up, and SC General is not filled up, my lord.
Zone 6, 6, 7,
Page number 26, my lord.
Yes, yes. How many posts were notified?
14 posts, my lord.
No, there are only 12 posts.
14 posts, my lord. Page number 10, my lord.
What is BL? Your BL or Gen? BL means backlog.
Backlog, my lord.
Backlog, 3 vacancies.
Page number 10, my lord.
Yes.
Mechanical branch, serial number 6.
Yes.
For General SC 1, my lord. The petitioner belongs to scheduled caste.
Yes.
But no scheduled caste has been appointed, my lord. And out of that, 14 posts are notified.
Yes.
Out of 14 posts, 7 posts were filled, and in that, not even one candidate is there from scheduled caste general, my lord.
You are concerned with your vacancy, SC general vacancy.
Yes, my lord.
Yes, Suran.
Milord.
Yes.
Handicapped with the bundle, Milord. But maybe taken up next week, Milord.
We are making very clear that no adjournment will be granted in any case up to 2013.
Hello.
Request of the respondent. Counter is also not filed. Finally, we will adjourn it for 21st. It requires the respondent to file counter as a last chance. Post on 21/11/2022, 2023 for orders.
Obliged, my lord.
Item 45, HMS, don't send us.
The petition does not suffice.
When the matter is taken up for hearing. What is the matter about? What is the matter about?
Because prayer sought in the petition is to provide alternative employment.
Yes, that was provided.
The counter affidavit that the father provided alternative employment. 11/9/2013. Petition was
And pay the salary from so and so. The further prayer is there.
Lord salary, Lord, similar matter where again has appeared. Lord, this honorable court taken a view that Lord not entitled for that. Process justice subject to the class part of Lord. Number 1716 of 2013. Similar issue.
Yes. Please read the relevant para.
The first page itself, Lord, the paragraph 2. The case of the petition is that he was appointed as so and so. The respondent corporation while in the year 2010, the respondent.
So what is the reason given in this case, in this judgment?
Lord, the same the low vision, Lord.
Yes, relevant para.
Lord, he is seeking, Lord, the first page itself of the 1716 order, Lord. Last 5 lines. Thereafter, petitioner was provided an alternative employment as farming and proceeded commodity depot by proceeding counter services. However, without extending the pay production in the catalog, also without paying salary from November 2010 to July 2011. Proceeding the same if the petition is filed.
Yes.
Lord, the honorable court has considered various judgments, Lord, as
Yes.
well as the provisions of section 47(1).
No, this court has, while admitting the petition, second para, second page, has issued interim direction to the respondent to fix the pay in the cadre of grade 1 driver and pay the salary. What happened to that?
In that matter, this order was passed. In this Milord, I filed a counter affidavit that his pay protection was granted.
No, what is the, please come to conclusion of the judgment.
Judgment, Milord.
That was paid or not?
But his salaries were not paid. He is not entitled for that.
Please show me the declaration from this court.
Milord, your lordships are aware, Milord, the Honorable Supreme Court judgment, Milord, where section 1 only 3 persons covers under section 2I of the Act.
Yes.
Not disregarded. Milord, the petitioner disability also does not fall under that category. So therefore, Milord.
Where is the relevant para in the judgment? 2I whether.
Milord, page 5, your lordship may kindly see.
Page 4.
Page 5, peruse the material on record. It is
Yes.
pertinent to note that whether the petitioner corporation has taken a specific stand in both counter affidavit as well as out in the additional counter affidavit. But no protection has been given to the petitioner has not bothered to file any reply denying the state protection has not been provided. Further, Honorable Supreme Court by dealing with the Honorable Civil Appeal number so and that
Give a copy to him. Not give a copy to him.
sort of
So that he will also follow the court. Otherwise, he has to answer his friend given. Yes.
the extraction of Lord the Supreme Court is extracted.
Yes.
Thereafter, following the said ratio, the judgment of this Honorable Court has disposed of HRP number 3 of 2017 advance by common judgment dated by holding that following the order of the Supreme Court in civil appeal number and batch, these writ appeals are also disposed of, holding that the benefit of section 47 of the Act shall be available to only those who are covered by the disability specified in 2A of the Act. It is open to the appeal corporation to take a decision on individual grievance of the respondent and petitioner. That will utmost expedition, preferably within 3 months from the date of receipt of the corporate order. The respondent and petitioner are at liberty to thereafter to apply their remedies in terms of the judgment. The common judgment of dated 5/6/27 has also been followed by another division bench of this court in writ appeal number 196 of 2017 and batch dated 25/3/2022. Lord, but thereafter also, Lord, your lordship was holding the division bench with our lordship. Simon Chowdhury also disposed of the similar matters about the same place.
Yes.
Thereafter, Lord, and with regard to the issue laid down by Honorable Court in so followed by the division bench Honorable Court in Disciplinary number 1. So that common judgment dated passing Disciplinary number 196 of 27 and court does not see any merit to grant the prayer sought in the petition. According to the the counter affidavit filed by the corporation and specific stand has been taken that the pay protection has been granted by the response corporation but providing alternative employment to the petition that Shami. Said protection shall continue. However, in case the petition still are making legal regarding pay exceptions, it is open to the petitioner to avail these remedies available. Pay settlement has been reached by the corporation and the employees. So, not the salaries for which the petitioner has claimed was not granted in this petition. Not the same council argued in this matter and Honorable Court has and the specific stand also taken in counter affidavit.
Yes.
Paragraph 6 of my counter affidavit. Yes. The period that the medical board of the corporation examined the petition on 2013 and declared that the petitioner is unfit for the post of driver due to defective distant vision, left eye, and considered that he is fit for alternative employment. Yes. Accordingly, petitioner was found fit for the post of Brahmi. He was provided alternative employment as Shami. He reported a bonus as Shami on so and so. His pay in the post of driver has been protected and fixed in the scale of Kamil as per the success. Pay ranges from the date on which he was declared for the post. He is provided alternatives.
So we pass same order.
Yes.
Yes, come. Same judgment we are following. We follow that.
To consider the case.
There also interim, same number. There also. So what happened to the interim order? You consider the case of petition for providing alternate employment. Shramik.
Yes.
It's not using the disposal.
The same order. Yes.
But
Item 46, the rest of the mother is
My lord,
Yes.
my lord, in this writ petition, the petitioner is seeking that to reduce the cutoff marks and call the petitioner for trade test. And this honorable court are pleased to grant an interim order to allow the petitioner to trade test. They were allowed to trade test. After the trade test, because they have not secured the cutoff marks, they were not selected. So nothing survives in this writ petition.
Yes.
May I read the prayer, my lord?
Read.
And consequently direct the respondent to reduce the cutoff marks appropriately by considering the factum of absence of 429 candidates for verification of their original certificate pursuant to notification so and so, and accordingly permit the petitioner to trade test and consider petitioner cases for appointment as junior branch attendant. And this honorable court was pleased to grant interim order to allow them to trade test. Accordingly, they were allowed to trade test. And after the test, finally, they have not secured the cutoff marks because the first petitioner secured 74.54 marks, whereas the cutoff mark for non-local is 83.23 and for local it is 80.31. In such a way, all the 14 petitioners have not secured the cutoff mark, so they were not selected.
Where did
So
you
this is,
where did you state it in your affidavit?
Mila?
Where did you state it in affidavit? Which para? Have you stated all these details in your counter?
Milad, they were not given to them, Milad, because they are the marks. I was given instruction, the prayer in this repetition to allow them to trade test. They were allowed to trade test.
Sir, you have filed your counter.
Yes, I filed, Milad.
Where did you state it that all these facts? Have you stated in your counter?
Oh, no, Milad, the cutoff marks that we have not stated in the counter. They have not stated in it. What they stated is, they were allowed to trade test, and after the trade test, because they have not secured the cutoff marks, they were not selected.
So file an affidavit to that effect. Request the respondent to file an affidavit.
Mentioning.
Yes, by giving all details, mentioning all the particulars.
Much obliged.
No, when the matter is the council appearing to the respondent submit them. So now we can't record all your oral statements. It must be on record.
Much up.
Item 47.
To which date it is posted, Mina?
21/11
Much up.
as a last chance.
My lord, CL number 47, my lord.
Yes.
The petitioner actually studied ITI draftsman civil, my lord, but it was wrongly uploaded as ITI draftsman mechanical.
IA 1 of 2023.
Yes, my lord.
What is this? Additional material paper.
That is service certificate.
Have you served on the other side?
It's served, my lord.
Yes, Suran.
My lord, the petitioner is pursuing draftsman civil. That
Okay.
is the requisite qualification for contract labor. The petitioners have not filed any proof of document showing that they are contract laborers. Now they want to file the certificate to change the color that they are contract laborer so that they are possessing the qualification. Therefore, this can, because they want to change the entire case itself by way of this amendment petition, the additional material paper.
We'll attend next week. Please come physically and argue the case. It's request of the respondent post on 16.
My lord, on last occasion, lordship directed them to get the record, my lord.
Yes, Suryanarayan, what happened to record?
No, because they have not produced, they have not filed any paper to show that they are contract laborers. Now they want to bring the papers in the record. Had they processed really, they would have filed it along with the writ petition itself. They have not filed anything. Now they want to bring all these certificates to give a color that they are contract laborers.
My lord, page number 12, in her application, she stated, my lord.
Maybe, my lord, they may state, but they have not filed any proof. The service certificates which they have not filed at the time of application can't be taken into consideration now.
Suryanarayan,
My lord.
on 17/10/2023, this court directed to produce the record. Please
Yes,
produce.
my lord.
Yes, for production of records. Post on 14/11.
Obliged.
Item 48, Radhamohan. A. Krishnan.
Yes. Yes, sir.
The lordship may kindly have it tomorrow.
What is the matter? What is the matter about, sir?
The lordship, the matter is regarding.
Already 5 days counter. Therefore, it is decided to
Proceed.
not prepared for today.
The 2013 matter, sir.
4 years this has come.
No.
See, the last
19/4
was in 2019.
19/4/2022. IA was ordered. Thereafter,
Showing pending.
yes. Request of the parties, post on when do you want?
57th of this month.
27th holiday. What is the matter about?
Voluntary appointment of service reduction.
Authorized jobs.
Post on 16/11.
Item 49, relates to the capital of tension.
What is the matter about?
Relation to.
It's coming for your instructions.
Yes, ma'am.
So what are your instructions?
11.
This court has directed to get instruction.
Yes, ma'am. Some out of 10, but I think to secure some. Subsequent to appointment, my lord, they were regularized with effect from 2013 and 16, and they on in the year 2013 and 16, and they were given benefit from the date of appointment, that is 2/8/2011.
Yes.
There is a reputation that they are claiming from 2007 onwards. Sorry, yes, 2007.
Yes.
In fact, when they were appointed in 2011 or 2/8/2011, they did not challenge the appointment order, saying that should be with effect from 2007 notification. Now, after 2 years of that, they filed a petition. Well, in relation to few of the petitioners, I security inspection when the date from which they were regularized, and from which date, immediately from the date of appointment, they were given benefits. Remaining will have 3 or 4. I should I say next? Second.
Not paying the regular time scale of pay with all consequential benefits on par with 2007 and appointees pursuant to the notification, pursuant to the orders Orders of this court and WP numbers.
But they were admittedly appointed in 2011. But they did not say that.
As per the orders of this, as per the orders of this court.
No, they were. No, that my friend is taking prayer. There is an order of the Honorable Court in WP number 8794 of 2007 and batch. But that was decided by the Honorable Supreme Court. But anyway, we appointed the Millard in 2011. After the order of the Supreme Court vacation, then we even regularization with effect from 2011.
No, on what basis they are seeking?
Now they said because they were applied in terms of 2007.
Why was it delayed? Counter 5?
Yes. They were considered the fresh candidates.
Where is the appointment order?
But I have instructions saying that they were appointed. Some of only 6 I could.
Madam, have you filed any appointment orders?
No, it was not filed. And the appointment order is now challenge saying that it should be from 2007. And admittedly 2013.
వాళ్ళకి రిటైర్ అయ్యేదాకా ఏం కావాలి కదా లాస్ట్ సర్వీసులు రాకుండా ఛాలెంజ్ చేస్తే
But back to that they were given benefit from 2011, all 10. So
we'll see, get instructions. Request to the petitioner. When do you want? Sorry.
20 we can.
21 level. In the meanwhile, it's not the director to get instructions.
May I please, Milad?
Yes.
Milad, this retreat director is the order, the expert order dated 23rd of August 2012, passed by the first respondent under section 20 of the Minimum Wage Act. Well, the direction is that I should deposit an amount of 2,25,000 to being the so-called difference of wages payable to the workman.
Yes, GP.
10 times come.
1 second, sir.
Yes.
For labor appeals, last occasion also.
Where is labor GP? Where is GP labor? Yes, sir. None of for the respondents. Post on 1611 and registry directed to print the name of comply with the order dated 4/10/2023. Sir, next week.
Very good.
Item 52. Case registry. Case request.
This was found father minority. It was not treated in that this is direct. They know what is in it. Of 7 page scale on that settlement. All of a sudden, you have filed is also granting interest. Now they have filed counter. It's not for hearing that. It was not.
At request of the petitioner, none of for the petitioner. Post next week and registry directed to print the name. Ms. Vyoma Devi in place of case of the case was made.
But petition responding.
We said.
Yes.
Registry directed to print the name of Vyoma Devi in place of Mukti. Yes.
Item 53. V. Narasimha, Madam Srinivas.
Yes.
Annual returns for regulated 2 years. They are not served the preliminary report. They are not served the report of assistant mechanical engineer. Moreover, whether the joint action committee member is one of the member is cause of this punishment. This is a discrimination.
Is the driver?
Yes, the accident.
Where is the punishment order? Final orders. Depot manager. Where is the inquiry report? One passenger leg fracture, 3 passengers received blood injuries. Yes.
Inquiry.
Counter filed.
Inquiry report is not filed.
Counter is filed. Or?
Counter is not. Yeah, very counter. They say they have inquiry. Inquiry also.
Today you are filing. That request.
Inquiry report.
A request of the standing council to file counter post on 21.
Item 54. Give this date. Give it for एक data.
Last question, last which stop counter. Last question, the counter was not available.
Sure. Please file in the registry. Request with the respondent. File in the registry, sir. Long back, 2015.
Recently, after that,
This is on the face of this. No, this is filed in the registry. This is filed in the registry or not? Stamp on it. The counter. Old counter. The old counter. Old copy. 2015 copy. This is Jyoti computer.
Yes, these are
private organization.
You are appearing for organization or unofficial respondent?
Sir, private organization. For number 3, who is in non-supply power?
Or 3. Notice to offer served on
proof of service period. And it was shown that okay, existing.
when did you file?
Just 22 itself.
2022.
Yes. Application is already verified.
I think delivery.
Yes. Here we are challenging the appointment of post respondent. Against the petition post respondent. Subsequently, a filed amendment petition will not impede that person. All the notice no offense was made. The issue is that when they replace designing it temporary to employment, they engage other note temporary. That is bad enough.
Yes.
Human judgment also. If there is a regular post there is no such issue. But in my case, designing my services and replaced by another temporary employee, that is good to
Why R1 and R2 made as party?
because the was provided to the first respondent, that is the state. The work belongs to state government.
Who is appearing for R1 and R2? Government.
A question for consideration.
Yes, sir.
He is data entry operator 4. They have fixed the minimum education qualification graduate.
Yes.
The person petition is not undergraduate.
Where is the notification? Yes, so there is.
Simply they are like, now petition working more than 10 to 15 years.
Please proceed. What is? Please show me the notification or.
There is no notification. This are page 13.
No, on what basis you are saying? Graduation is the.
The second respondent, whom we have supplied the manpower, he says.
No, where did we get that information?
Find out.
We are saying that the prescribed qualification is degree.
Yes.
Let's produce that.
Moreover,
Is there any stay?
Because it's a private agency,
Yes. How the writ is maintainable?
The works belongs to R1, R2, the work entrusted to the fourth respondent.
They have to say that they have not filed any counter so far.
They have also filed.
R1 and R2. File counters? No, we'll see. Get it informed to Brahma post on 2111. The request of the respondent number 3 post on 2111.
Item 55, Srinivas Yamani, K. Udeshri.
And appears for the petitioner post on 2111.
Petition.
Yes, sir. Urgent 2111. Yes, next.
In fact, in this matter, that counters have been filed and replies also filed.
Yes. Counter file counter in the registry.
Counter is filed, but reply is also filed. But case of compassionate.
Srinivas Garu, counter is
Sir.
not available in our bundle. We are directing the respond to file counter in the registry.
Yes, fine.
Post on 2111.
Yes.
And response are directed to file the counter in the registry.
Okay.
Item 56, B. Sriram Krishna. Typical registration.
For respondent number 3.
And appears for the petitioner post on. Post on 2 weeks. 15 hours. 59, 56. Count is already filed, but it is not in our condition. 56 and 59. Post after 2 weeks, that is on 23 level. None appear for the petitioner, post on 23 level.
Item 57, B. Sudhakar Reddy, Additional Advocate General.
What is the issue? Yes. What did they say? File? File? When did you file? What was the date? And appears for the petitioner post next week. What was that? What will it? And response are directed. In the meanwhile, response are directed to file counter in the registry.
Item 16, A.K. Jayaprakash Rao, P. Banu Prakash.
There are 3 applications. Permission petition. To permit to file the document.
All those are ordered. Permission petition, amendment petition, implement petition, all 3 are ordered.
The most atrocious thing is that the employees who have not completed 5 years of service, they were regularized. Those who have completed, they were not regularized.
Yes, Venkataraman. File? Yet to be filed.
years.
25. Monday. When do you want? When do you want? 1 week?
2 weeks.
Or 2016, 6 years. GP. GP services 1, 6, 4 weeks time for filing of counter. What is this, your case? No, who is to regularizing authority? It's the government. Your name is not there.
60 lakhs.
Yes. The requester respond to file counter post after 2 weeks. And register is directed to be in the name of government for GP services 1. Both of you file counters.
Item 61, P. Lakshman Reddy. P. Umadev.
Yes. Next. Counter file, Surana?
Filed, Mela.
Counter. Yes. Yes, next week. Yes.
Achha.
No, 1 second.
Item 62, registration GP per labor.
Big time. What is the matter about?
About challenging the order district whether in CMA in concerns with the order of first respondent. PW case number 2 of 2006.
Vijay Kumara. Post for yes.
The orders passed by the respondent number 1 and also the orders passed by principal district judge CFM. That's the main contention is that petitioner doesn't come under Payment of Wages Act. It's not an industry or establishment under the Payment of Wages Act. We request 1 week minutes.
Request to the petitioner. Post on 16 level. That's okay.
Item
Another place of the response.
Item 63, E. Venkata Reddy. GP per Pansakra.
And represented by Fiscal time for 90 minutes.
Your for?
Petitioner.
Yes, what is the issue? Yes.
Wasting time.
2011 matter, there is no stay. What is that? Request to the petitioner. I'm not prepared to respond. They took the petition post on 16 level.
Item 64, we partner with GP for level. Please read that.
None appears for the petitioner post next week for dismissal.
Item 65, is not GP for social welfare.
None appears for the petitioner post next week.
Item 66 and 67, M. Radhakrishnamoorthy. GP for level.
I'll take this to same hour. Petition for the service plan. In case ID, it was granted a fresh measure. I was charging management charging a fresh measure. Current marks for candidate of person practice. And then they both state any mistake, any.
ఈరోజు బాగాలేదా ముహూర్తం? None appear for the petitioner. Radhakrishnamoorthy, you are repeating Radhakrishnamoorthy or? You are repeating both the counsels. Ms. Sudha appearing for the both the counsels, representing both. Yes, at request of the parties post next week on 16 level.
Item 69, SK minor this, N. Musundareddy. Madam Speaker.
Yes. What are your instructions?
Instructions and no bundle also.
This is no bundle also. Regarding section 47 of things, 43209 proceedings, circular. Employment to medically unfit drivers to the post of record tracer order, 43209 circular. They are seeking to declare the action was conferring the benefit of alternate employment to the post. Not extend the benefit of 43209 benefits. At request of the respondent, none appear for the petitioner. Yes, that's the reason we are asking to get instructions. Notice of request given me. On 30 August 2023, registries therefore directed to verify whether the notice already issued. Next till pending. Yes, await service of notice and the meanwhile post after 2 weeks. In the meanwhile, response are directed to get instructions. If that is extended, we will close the requisition. No, waiting. Post next week, 16/11. Get instructions. We'll dispose of the repeats. Why unnecessary people?
Item 30, TSP suggestion. Dear Mother.
Yes.
Media council is Shotalan season item. It is also between the nuts. I request because I have to appear to your lunch. Next week, others will.
Yes, respond council.
Mila, this is against dismissal from service, Mila.
Dismissal. It seems to against inquiry order. Inquiry report, it seems.
Yes, ma'am.
Calling for records relating to pertains to
Inquiry report and the impugned order is dismissal from service, which is confirmed by in the appeal.
counter is filed.
Yes, my lord.
And then, yes, I request the request of the
June 2013 counter is filed.
yes, yes. Post on 16th.
Much obliged.
Item 71, Kondapatti Kiran Smart. Dear Mother.
My lord, we are bundle is not traceable, my lord. Next week may be taken up.
For the prediction, you have filed a reply. This is the reply.
Counter is filed.
Yes, sir.
Counter in that.
Send the reply already.
Now, 2012 matter, you are filing reply. When did they file their counter? When did they file? Surana, have you filed your count?
My lord, bundle is not traceable, my lord. So I am handicapped, my lord.
When did you file? When did they file? You don't know. I request the parties post next week.
Much obliged.
Item 72, Accommissioners. Deputy Limit.
Second respondent management.
Yes.
Taken the notice, right?
What is the user number?
Street 10, 2026.
The against idea what?
Idea.
You are appearing for management.
No, no. Milord, I think that Milord, there is no notice, no inquiry. The petitioner was refused Milord from attending one.
Partly allowed direct state to effect the retirement of social compulsory.
Yes. Against that Milord, having held Milord that there is a
Yes.
no inquiry Milord.
What is the order? In Eru,
Senate.
Senate?
Senate.
23. No? R3. Yes, what is the USR number? I got service of notice. And registry is directed to put up the proof of service filed by the petitioner. For USR number, dated service. Is that particulars?
Yes.
Post on 16/11. Yes, next. Complete the list.
Item 73, TS Prevent Kumar. Deputy for Technical Education.
So what is the issue?
Issue is returning the payment of PRC 2006 to the petitioner.
Counter is filed.
Counter is filed.
Yeah.
Counter is filed. Say 1 week time.
What is the issue?
Regarding the payment of the
Not to-
PRC.
No. Please read your prayer.
No, in fact, direction in nature of writ of mandamus, otherwise declaring the inaction on the part of the respondents in not taking action on the representation dated of the petition and consequently not paying the salary and allowances as per the PRC recommendations is bad and illegal argument.
Page 12. Please read page 12. It is therefore paid that This honorable court may please to issue a writ or order or direction in the nature of mandamus or otherwise declaring the inaction of the on the part of the respondents in not taking action on the representation dated 7/3/2013.
Consequently, they not paying the salary and allowances as per the PRC recommendation.
We'll allow the request of the direction to consider your
They
representation.
already considered the representation. So in the representation, they have stated that if there are any areas, they are going to pay you.
Yes.
In fact, my information from the client is, you know, that we are eligible.
Where is that speaking order?
Speaking order is filed along with the counter.
We will close the restriction.
In fact, one submission. My submission is that we are eligible for 24 lakhs. And another 8 lakhs has to be paid, you know. Even as per their consideration of the representation, they stated that if there are any areas, they will pay. So last time I had a short time, your lordship to get instructions from my client. Now I got instructions that there are another 8 lakhs rupees has to be paid from
Counter is not enough.
Counter is
Yes,
also.
who is appearing for respondent?
No, arrangement is appearing. I also informed that I am going to file it. The lordship may take after 1 week, you will file a reply on the commission. In fact, on the last occasion also, I made a submission that as per the Supreme Court order, the petitioner is eligible for the PRC norms.
Where is that copy? Well,
Last occasion, you launched by give the argument.
yes, it's request of the. You are appearing for respondent. Who is appearing for state? Special GP. None of it.
The contesting respondent is carried the person. College, for the college is respondent, carried the person. Last time was the he has sought him. The last occasion, on the earlier occasion, I have sought him.
Yes, sir. Yes.
Yes.
None appear for the respondent. Post next week. What is your reply about USR number?
That I will
Yes. Yes, next.
Item 34, D. Venkat Keep it the finance.
my lordship. Taking on behalf of organization 19 was time for working.
Yes. GP Finance. You are representing? You are appearing for whom? You are appearing for? M. Salim. M. Salim lady on the list. Yes, what is the issue? None appear for this. Respond. What are this in? Yes, none appear for the response. Post next week.